Welcome to Requiro. Today we are going to be talking about Karen Agnifilo's 89-page pre-hearing memorandum of law that came out on the 30th of January 2026. Now that I struggled with that so much for like 5 minutes before I restarted doing this. Anyway, enough of me bragging. So I do want to say this here before we get into the main part of the video, aka the audio version of this document, is I do recommend to read this document or just listen to this video, because I think it very much packs of all the very much important information that came out in the itty-bitty details of things that happened in the December suppression hearing in Luigi Mangione's case. And I very much recommend to go just read or listen to this document if you guys don't want to go read all the live tweets that are on my website on the when I was covering the live tweets from the December suppression hearing in Luigi Mangione's case. If you want to read them, or if you just want to go check out those videos, they're there too. But if you guys don't want to do that and you don't have time to listen to a 6-hour, 5-hour, 2-hour long video, you just want all the important information, I recommend just to go listen to this video or read this document. But it does go over the very small details that came out from the Altoona police officers and the hiccups they all did, and all that little important information that came out in the small detail things in a lot more detail and a lot more thorough, and how I did it. And you don't have to sit through a 6-hour long video, you can just read this document. I do recommend it. It's a lot more condensed, it does get to the point quite quickly, and it has all the very much small important details and things in this document, so I do recommend it. So technically this document is about 158 pages, but basically from page 90 onwards it is literally the transcript from the 23rd of January 2026 hearing in Luigi Mangione's case, and I'll make that its own dedicated video because that did come out in January, so I'll make that its own dedicated video. And I don't want to have it recorded twice, because I don't want you guys to go listen to this video and then it's there and then it comes out again. I just don't want to repeat myself here. I did say in my last video, this video will be me going over the updates in Luigi Mangione's case, but just because there is a couple of really big documents, 50 pages plus, and I don't want to make more of Lord of the Rings style type of videos that go for 6 hours. You guys probably don't want to listen to that either, so it is easier for me to just cover these really massive documents and then take notes as I'm doing these. So that's why we're making this video instead of me going the updates and all that. Hopefully that'll be next week's video, going over the majority of the updates of December and January, and then I will go over the February and then March documents, if that makes sense. Again, it'll just be easier to me to tackle and film and edit for you guys, because I feel like you guys don't really want to watch and sit through a 6-hour long video. I don't like making 6-hour long videos. I feel like you guys don't like listening to 6-hour long videos. Anyway, we're moving off from that. Also, yes, I am wearing a beanie in this video. I went out today and I was wearing it because it is cold, and the colder it gets, the more emo I become. Anyway, and also I have hat hair, so I might as well just leave it on. I don't wear hats inside. I think it's a manners thing. Anyway, and I'll go over my little breakdown and all that in my next video, going over the updates in Luigi Mangione's case of this document. This is just basically a audio version of this document. The information and all the sources in this week's video will be up on the website on this week's episode, and if there's anything I got wrong or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. I am one person working on all these little videos I do, and I do make mistakes, and I am human. Now, let's get into the video. Hey, it's voiceover me. I do want to say sorry for some of the words and sentences. For some reason, it don't read the word correctly. I think it maybe just missed a letter and it kind of jumbled. I do not know why it did that this time around when I was doing the voice to text like I normally do when I make these little audio bits of the video, so I do apologize about that. I don't know why I did it this time around, and I found that quite odd. Anyway, I just thought I should put this here anyway.
Supreme Court of the State of New York, County of New York, the people of the State of New York, Sign 75,657/2024 Luigi Mangione, defendant. Post-Hearing Memorandum of Law in support of motions to suppress Karen Friedman Agnifilo, ESQ, Mark Agnifilo, ESQ, Jacob Kaplan, ESG, Agnifilo Intrator LLP 140 Broadway, Suite 2450 New York, New York 10005. Counsel for Luigi Mangione. Table of Contents. Preliminary Statement. Motion to suppress Mr. Mangone's backpack. Search incident to Audiophile arrest. Search for a bomb. Inventory search. Motion to suppress Mr. Mangone's statements. The December 2025 suppression hearings. A. Law enforcement's interactions with Mr. Mangione at the Mcdonald's. Mr. Mangone's arrest and the searches at the Mcdonald's. 1. The search of Mr. Mangione. The search of Mr. Mangone's backpack. Iaconek at the rear in the search of Mr. Mangione. The search of Mr. Mangone's backpack. Argument. A. All evidence recovered from Mr. Mangone's backpack must be suppressed because law enforcement failed to obtain a search warrant before searching the backpack. Legal standard. New York law and lease. Legal standard for searches incident to a lawful arrest in New York. Fagal standard for inventory Saucus in now rule.
Hey, voiceover, sorry for that loud noise before. I dropped my phone. And I made a very loud noise, so sorry about that.
Law enforcement's search of Mr. Mangone's backpack at the Mcdonald's was not a valid search incident to a lawful air. Law enforcement's search of Mr. Mangone's backpack at the Mcdonald's was not justified as a search for a bomb. Patrolwoman Wass's searches at the precinct were not valid inventory searches. The search on the metal folding chair. The hallway search. 3. The search in Patrolman Featherstone's office. B. Mr. Mangone's statements to law enforcement must be suppressed. Legal standard. Mr. Mangone's statements to law enforcement in the Mcdonald's should be suppressed. 3. Mr. Mangone's statements to corrections officers Henry and Rivers should be suppressed. Conclusion. Preliminary statement. On April 30th, 2025, counsel for Mr. Mangione filed an omnibus motion seeking, inter alia, 1. Suppression of the evidence seized at the time of his arrest because law enforcement conducted a warrantless search of Mr. Mangone's backpack in violation of his Fourth Amendment rights, and 2. Suppression of Mr. Mangone's statements to law enforcement as officers failed to provide him with Miranda warnings in violation of his Fifth Amendment rights. In December 2025, this court conducted a 9-day hearing to address counsel's suppression motions. As argued below, the hearing testimony demonstrated that Altoona law enforcement violated Mr. Mangone's constitutional rights numerous times by searching his backpack at the Mcdonald's without a warrant, by searching his backpack again at the precinct without a warrant, by reading his writings without a warrant, by failing to provide Mr. Mangione with Miranda warning before interrogating him, and by continuing to interrogate him even after he invoked his right to remain silent, and again after he was represented by counsel. For these reasons, this court should suppress the contents of the backpack and his writings, as well as Mr. Mangone's statements to law enforcement. A motion to suppress Mr. Mangone's backpack can need until Audiophile erect at the hearing. Altoona law enforcement officers repeatedly attempted to justify their warrantless search of Mr. Mangone's backpack at the Mcdonald's as a valid search incident to a lawful arrest. Instead, all these officers demonstrated was an utter disregard for a defendant's constitutional rights and a shocking ignorance of basic search and seizure case law. As discussed as addressed below, New York's suppression law applies here as New York is the forum state because the alleged crime occurred in New York and Mr. Mangione is being prosecuted in New York. Notably, as discussed below, Altoona law enforcement's conduct relating to the scar and seizure of Mr. Mangone's property also violated Supreme Court and Pennsylvania law. More detail below. The Altoona officers testified at the hearing that it was their standard procedure to search a defendant's bags after an arrest as a search incident to a lawful arrest and have never sought a search warrant. H.R. 219-91, 630, 755, 973. Altoona officers testified that they would search these bags, as they searched Mr. Mangone's backpack, without a warrant as a search incident to a lawful arrest, even if the bags were not in the control of, or in the immediate grabbable area of, the defendant at the time of his arrest. Such a search is prohibited under New York Pennsylvania and federal law. Here, the hearing evidence established without any doubt that Mr. Mangiane's backpack was not in his immediate control at the time of his arrest. This fact is confirmed by the body-worn camera footage of numerous officers, as well as their hearing testimony. As is demonstrated from the body-worn camera footage, law enforcement moved Mr. Mangiane's backpack outside of his immediate control approximately 17 minutes before he was placed in custody. Moreover, at the time of Mr. Mangiane's custodial detention, he was rear-cuffed and separated from his backpack by at least 5 officers, with another 7 officers in the immediate area in the back of the McDonald's. Given the body-worn camera footage and the law enforcement testimony at the suppression hearing establishing that the backpack was not in Mr. Mangiane's immediate control at the time of his arrest, there is no basis for the prosecution to argue that the backpack search at the McDonald's was a valid search incident to a lawful arrest. 7 Chark 40 Ramble at the hearing. The prosecution and Altoona law enforcement further claimed that the search of the backpack at the McDonald's was valid because law enforcement was searching the backpack to make sure there was no bomb, as detailed below. However, the totality of the circumstances demonstrates that law enforcement's claim about a bomb was a blatantly false and pretextual justification for conducting an evidentiary search. Most notably, the body-worn camera footage establishes that this was a search for evidence, not a search for a bomb or dangerous instrument, as law enforcement used its bomb claim as a basis to search items in the backpack that, as officers admitted at the hearing, were too small to contain a bomb. Moreover, that this bomb search was pretextual is further demonstrated by the fact that, once patrolwoman Christy Wasser found the loaded gun magazine in the backpack, patrolman Stephen Fox stated to Wasser, "Now that we found that, let's just take it back to the precinct." X6E, 1 at 10 hours, 1 minute, and 49 seconds, HR 813, 900, 901. If this truly were a search for a bomb, officers would have continued searching the backpack before taking it to the precinct, especially considering that neither patrolwoman Wasser nor patrolman Fox had finished searching the section of the backpack they were looking in, and neither had searched a third compartment in the backpack for a bomb. Instead, because this was an evidence search, Altoona officers stopped searching at the McDonald's once they found incriminating evidence and took the backpack to the precinct. Inventory search. The prosecution further claims that the contents of the backpack should be admitted because the backpack was properly searched at the precinct as an inventory search. Notably, at the McDonald's, 2 supervising officers voiced their concerns with the plan to continue searching Mr. Mangiane's backpack at the precinct without a warrant. Unfortunately, both higher and lower ranking officers ignored these concerns and instead chose to violate Mr. Mangiane's Fourth Amendment rights by continuing to search the backpack at the precinct without a warrant, justifying it interchangeably as both a continuation of their search incident to arrest and as an inventory search. As addressed below, there were at least 3 distinct searches of the backpack at the precinct. 1. Patrolwoman Wasser opening the backpack on a metal chair in the intake area to recover a firearm. 2. Patrolwoman Wasser's search of the backpack in a hallway in the precinct. And 3. More complete searches of the backpack conducted by Patrolman George Featherstone, Sergeant Eric Houston and others at various locations inside the precinct. As discussed below, the hearing evidence established that patrolwoman Wasser's searches were not inventory searches because, inter alia, no inventory was actually done, and her purpose in searching Mr. Mangiane's backpack was to find evidence to assist the NYPD in its homicide investigation and not to create an inventory. As to the more complete search of Mr. Mangiane's backpack subsequently conducted by other officers, this inventory search was improper because it exceeded the authorization provided by the Altoona Patrol Guide for 2 reasons. First, the Altoona Patrol Guide only allowed officers to conduct an inventory of the detainee's person, not items that were not on the detainee's person. Second, the patrol guide did not authorize officers to read the contents of Mr. Mangiane's writing, in his journal or otherwise, without a warrant. For all these reasons, and the reasons listed below, the contents of Mr. Mangiane's backpack and all his writings should be suppressed. B. Motion to suppress Mr. Mangiane's statements. Mr. Mangione also moved to suppress his statements to law enforcement at the McDonald's because he was not given his Miranda warning before being subject to custodial interrogation. As discussed below, after approaching Mr. Mangione and asking his name, Patrolman Joseph Detwiller started asking questions seeking to incriminate Mr. Mangione in the New York City shooting of Brian Thompson. These questions, including asking multiple times if Mr. Mangione had been to New York recently, were designed to elicit an incriminating response because, at that point, Patrolman Detwiller 100% believed that Mr. Mangione was the New York City shooter. HR 197-98, 224. Patrolman Detwiller also asked these questions as he and Patrolman Tyler Fry strategically positioned themselves in a manner that prevented Mr. Mangione from getting up from his seat and leaving the McDonald's. Law enforcement continued to question Mr. Mangione as additional officers responded to the McDonald's, further enforcing Mr. Mangone's belief that he was in custody and not free to leave the McDonald's. Because Mr. Mangione was subject to custodial interrogation, any statements he made before receiving Miranda warnings must be suppressed. Furthermore, once Miranda warnings were given, law enforcement continued to interrogate Mr. Mangione even after he invoked his Fifth Amendment right to remain silent. As argued below, any statement made after Mr. Mangione invoked his right to remain silent must also be suppressed. The prosecution also elicited testimony that Mr. Mangione made statements to corrections officers Thomas Rivers and Matthew Henry when he was housed in SCI Huntington. As argued below, the alleged statements to CO Rivers should be suppressed because these statements were obtained from Mr. Mangione after Rivers knew that Mangione had an attorney. Additionally, this court should find that the district attorney's office failed to meet its burden surrounding Mr. Mangone's alleged statements to CO Henry as Henry's testimony that Mr. Mangione, without any prompting, spontaneously starting making admissions about Herback Henry, who he had never met or spoken to before, was incredible as a matter of law. The December 2025 suppression hearings to resolve defendant's suppression claims. This court conducted a Mapple-Hunt-Lev hearing in December 2025. At this hearing, the district attorney's office called 17 witnesses, including 9 Altoona Police Department officers, 2 NYPD officers, 2 corrections officers, a 911 operator, a video custodian from the McDonald's, a Blair County prosecutor, and an analyst from the district attorney's office. The recitation of facts below is based on the hearing testimony, the body-worn camera footage and other exhibits admitted at the hearing. A. Law enforcement's interactions with Mr. Mangione at the McDonald's on December 4, 2024, at 6:45 a.m., United Healthcare CEO Brian Thompson was shot outside the company's annual investor conference at the New York Hilton Midtown. Mr. Thompson, who had been subject to previous threats, died at a local hospital approximately 30 minutes later. Following the shooting, the NYPD released video of the shooting and pictures of the masked suspect to the public. Within hours of the shooting, law enforcement also disseminated to the media and the public that 2 of the discharged shell casings had the words "deny and depose" inscribed on them, and that the word "delay" was inscribed on a bullet recovered at the scene. The NYPD began a nationwide manhunt to search for the masked perpetrator and also enlisted the help of the public by posting a reward for information leading to his capture. The testimony at the hearing was that, on the morning of December 9, 2024, employees and customers at a McDonald's in Altoona, Pennsylvania believed that a customer at the restaurant resembled the New York City shooter. At around 9:14 a.m., a McDonald's employee called Blair 911 to report that customers were suspicious of another customer that looked like the CEO shooter from New York. XSA, Blair 911 call, XSE, call for service detail report, I-65. At 9:28 a.m., Patrolman Joseph Detwiller and Tyler Fry of the Altoona Police Department responded to at the suppression hearing. Patrolman Stephen Fox incorrectly testified that the engravings on the shell casings stated "deny, depose and defend." HR 77778. The McDonald's restaurant, HR 1/8. Patrolman Detwiller, a 14-year veteran of the Altoona Police Department, had been familiar with videos and articles relating to the New York City shooter from watching Fox News. HR 17986. Patrolman Fry, a rookie officer 6 months out of the academy, knew only a small amount about the New York City shooting. HR 461. Arriving at the McDonald's, the patrolmen, both armed, in full uniform and displaying badges, approached Mr. Mangione at 9:29 a.m. as he sat at a table in the back of the restaurant. X6AL at 9 hours, 29 minutes, and 12 seconds, X6B, 1 at 9 hours, 29 minutes, and 12 seconds. As pictured below, Mr. Mangione was sitting at a covered tunnel with a wall behind him and a hecklet. 3209-20249 hours, 29 minutes, and 12 seconds. BWC2 024023 X6A 1 at 9.29 12. 3 Patrolman Detwiller and Fry positioned themselves to Mr. Mangone's right, blocking his only exit from the table as he was already surrounded by 2 walls and a table in front of him. X6B 1 at 9 hours, 29 minutes, and 16 seconds. Seconds after their arrival, they approached Mr. Mangione, both in uniform, and the still photos embedded in this motion are screenshots from the police body-worn camera footage that was admitted as evidence at the hearing. Armed, and asked Mr. Mangione to pull down his face mask, ID, at 9 hours, 29 minutes, and 13 seconds. When Mr. Mangione lowered his mask, Patrolman Detwiller immediately knew that the man in the McDonald's was the New York City shooter. HR 19798. Patrolman Detwiller then asked Mr. Mangione for his name. Mr. Mangione responded that his name was Mark and Mark Rosario, X6B, 1 at 9 hours, 29 minutes, and 20 seconds. Patrolman Detwiller told Mr. Mangione that someone had called the police because they thought he was suspicious. ID, at 9 hours, 29 minutes, and 27 seconds. In response to Patrolman Detwiller's request for identification, Mr. Mangione provided a New Jersey license in the name of Mark Rosario, X6B, 1 at 9 hours, 29 minutes, and 39 seconds. When Patrolman Fry left the immediate area to verify the license number, Patrolman Detwiller asked Mr. Mangione if he was from New Jersey and whether he had been to New York recently. X6A1 at 9 hours, 29 minutes, and 48 seconds. 9 hours, 30 minutes, and 0 seconds. As Mr. Mangione prepared to eat his food, Patrolman Detwiller moved even closer to Mr. Mangione and asked him what he was doing in New York. ID, at 9 hours, 30 minutes, and 11 seconds. 9 hours, 30 minutes, and 18 seconds. Before giving Mr. Mangione an opportunity to respond, Patrolman Detwiller asked him to stand up and put his hands on top of his head while Detwiller simultaneously grabbed and lifted Mr. Mangone's right wrist above his head. ID, at 9 hours, 30 minutes, and 24 seconds. 9 hours, 30 minutes, and 34 seconds. As Patrolman Detwiller frisked Mr. Mangione, he asked Mr. Mangione why he was nervous. ID, at 9 hours, 30 minutes, and 34 seconds. Patrolman Detwiller frisked Mr. Mangione for more than 15 seconds in front of Patrolman Fry and did not find any weapons or contraband on Mangione. ID, at 9 hours, 30 minutes, and 34 seconds. 9 hours, 30 minutes, and 51 seconds. During the frisk, Patrolman Fry pinned the Mark Rosario ID to his uniform. ID, at 9 hours, 30 minutes, and 36 seconds. Patrolman Detwiller then ordered Mr. Mangione to sit back down at the table. Mr. Mangione was cooperative and complied with every request. LD 9 hours, 30 minutes, and 51 seconds. 9 hours, 30 minutes, and 55 seconds. Patrolman Detwiller then directed Patrolman Fry to talk to Mr. Mangione, while Detwiller motioned for Fry to move physically closer to Mangione to reinforce Mangone's inability to X6A, 1 at 9 hours, 30 minutes, and 56 seconds. At Patrolman Detwiller's direction, Patrolman Fry assumed Detwiller's position, blocking Mr. Mangione from leaving the table and exiting the McDonald's. X6B, 1 at 9 hours, 31 minutes, and 0 seconds. Patrolman Fry moved next to Mr. Mangione at around 9:31 a.m. and never left high position for roughly 30 minutes. As Patrolman Fry effectively had Mr. Mangione in custody while he stood watch over him and blocked any potential exit, Patrolman Detwiller took the Mark Rosario ID from Fry and went outside to call Lieutenant Tom Hanelli. During this call, which took place 2 minutes after Patrolman Detwiller approached Mr. Mangione, Detwiller told Lieutenant Hanelli that he was 100% sure that Mangione was the individual that law enforcement was looking for in connection to December 4, 2024, shooting in New York. X6A, 1 at 9 hours, 31 minutes, and 38 seconds to 9 hours, 31 minutes, and 57 seconds, HR 203. Patrolman Detwiller asked Lieutenant Hanelli, "Why don't you come out here?" X6A, 1 at 9 hours, 31 minutes, and 59 seconds. Patrolman Detwiller returned to the back area of the McDonald's to further interrogate Mr. Mangione and asked if he was from New Jersey, what he was doing in Altoona and, again, whether he had been 10 New York recently. X6A, 1 at 9 hours, 32 minutes, and 8 seconds to 9 hours, 33 minutes, and 11 seconds. Even though Patrolman Detwiller had already concluded that Mr. Mangione was the New York shooter, he told Mr. Mangione, as a pretext for the police interaction, that they were there because Mr. Mangione had been at the McDonald's for too long. ID, at 9 hours, 33 minutes, and 31 seconds 9 hours, 33 minutes, and 42 seconds. Patrolman Detwiller also admittedly lied to Mr. Mangione by telling him that they would let Mr. Mangione leave the McDonald's once they verified his identity. ID, at 9 hours, 33 minutes, and 22 seconds 9 hours, 33 minutes, and 28 seconds, HR 208. Patrolman Fry remained in his strategic position blocking Mr. Mangone's exit as Patrolman Detwiller continued interrogating Mr. Mangione. 1 at 9 hours, 36 minutes, and 32 seconds. At 9:35 a.m., Patrolman Detwiller again asked Mr. Mangione why he was in Altoona and where he was from. X6B, at 9 hours, 35 minutes, and 0 seconds. Patrolman Detwiller continued to lie to Mr. Mangione by telling him that he had been to the McDonald's 6 times in the last week for people staying too long at the restaurant. X6A, 1 at 9 hours, 36 minutes, and 2 seconds, HR 210, 382, at 9 hours, 37 minutes, and 36 seconds AM, Patrolman Detwiller pinned the Mark Rosario ID to his uniform. X6B, 1 at 9 hours, 37 minutes, and 36 seconds. As Patrolman Detwiller and Fry waited for Lieutenant Hanelli to arrive, Detwiller continued to speak to Mr. Mangione and, at one point, began whistling along with the Christmas carols that were playing at the McDonald's. LD at 9 hours, 40 minutes, and 15 seconds. At 9:35 a.m., 6 minutes after Patrolman Detwiller and Fry had arrived at McDonald's and 4 minutes after Hanelli received the call from Detwiller saying he was sure Mr. Mangione was the New York shooter, Lieutenant Hanelli called NYPD's 911 center on his way to get the ball rolling with the NYPD. X14, Lieutenant Hanelli's call log, HR 1003. 1 minute later, Lieutenant Hanelli called the NYPD's 911 center again and was still on the phone with them when he arrived at the McDonald's at 9:40 a.m. X14, HR 1004. Lieutenant Hanelli entered through the side door and immediately took the Mark Rosario ID from Patrolman Detwiller. X6B, 1 at 9 hours, 40 minutes, and 54 seconds 9 hours, 41 minutes, and 2 seconds. Seconds later, more than 12 minutes after he had first approached Mr. Mangione, Patrolman Detwiller moved a backpack from the floor where Patrolman Fry had been blocking Mr. Mangone's path to an area far out of Mr. Mangone's reach. X6A, 1 at 9 hours, 41 minutes, and 8 seconds. Sergeant John Burns, a supervisor at the Altoona Police Department, entered the McDonald's approximately 30 seconds later. ID, 9 hours, 30 minutes, and 35 seconds. Almost immediately after entering, Sergeant Burns motioned to Patrolman Detwiller asking if he had frisked Mr. Mangione. LD at 9 hours, 41 minutes, and 49 seconds. Patrolman Detwiller responded affirmatively that he had already frisked him. Sergeant Burns did not frisk Mr. Mangione himself or ask Patrolman Detwiller to frisk him a second time because he trusted that Detwiller did his job correctly. HR 1074, at 9 hours, 41 minutes, and 54 seconds AM, Corporal Garrett Trent arrived at the McDonald's, X6AR at 9 hours, 41 minutes, and 54 seconds. At that time, there were 5 officers in the back of the McDonald's near Mr. Mangione, Patrolman Detwiller, Patrolman Fry, Lieutenant Hanelli, Sergeant Burns and Corporal Trent. Neither Lieutenant Hanelli nor Sergeant Burns, the supervising officers at the scene, asked Patrolman Detwiller or Patrolman Fry to move the backpack further away from Mr. Mangione. HR 1074. Sergeant Burns explained at the hearing that he did not feel the need to move the backpack from where it was because there was no immediate threat as the bag wasn't within reach of the defendant at the time and there was plenty of officers standing around. HR 1075. Sergeant Burns also noted that both Patrolman Detwiller and Fry were standing between Mr. Mangione and the backpack. ID. 1 minute later, 2 additional uniformed and armed officers entered the back area of the McDonald's where Mr. Mangione was being held. Patrolman Sam McCoy, X6A, 1 at 9 hours, 42 minutes, and 35 seconds, and Patrolman Luke Yeager ID, at 9 hours, 42 minutes, and 36 seconds. At the same time, another officer, Corporal Brian Miller, entered the McDonald's from the front entrance and walked to the back dining area where Mr. Mangione and the other officers were located. X6G at 9 hours, 42 minutes, and 15 seconds. Patrolman Detwiller ordered Patrolman McCoy to take his place and stand next to Patrolman Fry, forming an armed human wall further trapping Mr. Mangione at the back of the restaurant. X6A, 1 at 9 hours, 42 minutes, and 38 seconds. From a safety perspective, Lieutenant Hanelli was content with how officers were around Mr. Mangione and that Mr. Mangione was considered detained at that point. HR 1006. As Patrolmen Fry, Yeager and McCoy stood watch over Mr. Mangione, Patrolman Detwiller walked outside to talk with Lieutenant Hanelli, Sergeant Burns and Corporal Trent to confirm that Mr. Mangione fit the description of the New York suspect. X6A, 9 hours, 42 minutes, and 49 seconds. Sergeant Burns testified at the hearing that he had no safety concerns with leaving Patrolmen Fry, Yeager and McCoy alone with Mr. Mangione because Mangione had already been frisked for weapons and the backpack had been away from Mangone's immediate reach. HR 1078. Sergeant Burns further noted that Patrolmen Fry, Yeager and McCoy were all trained officers capable of handling Mr. Mangione. ID Patrolman McCoy approached Mr. Mangione and asked if he had any weapons on him. X6B, 1 at 9 hours, 42 minutes, and 49 seconds. Patrolman McCoy asked Patrolman Fry if they had already patted him down. ID, at 9 hours, 42 minutes, and 52 seconds. After Patrolman Fry informed Patrolman McCoy that Patrolman Detwiller had frisked Mr. Mangione, McCoy did not frisk Mr. Mangione again. Patrolman McCoy asked Sergeant Burns acknowledged that a suspect could be considered detained even when he was not handcuffed, and that a suspect could be considered detained even without an officer informing the Clicknet 1 Hat Newak Maintenance Sale 1091. Mangione if the backpack and laptop near Patrolman Fry belonged to Mangione. X6C at 9 hours, 42 minutes, and 55 seconds. Mr. Mangione replied that they were his, as Patrolman McCoy moved the property to an adjacent table that was even further away from Mr. Mangione. ID, at 9 hours, 42 minutes, and 57 seconds 9 hours, 43 minutes, and 6 seconds. Patrolman McCoy then asked Mr. Mangione if he knew what all this nonsense was about. Mangione responded, "We will find out, I guess." X6B, 1 at 9 hours, 43 minutes, and 37 seconds 9 hours, 43 minutes, and 44 seconds, HR 1130. Patrolman McCoy continued to interrogate Mr. Mangione, asking if he was soaking wet, if he had walked there and if he had a car. ID, at 9 hours, 43 minutes, and 44 seconds to 9 hours, 43 minutes, and 59 seconds. In response to Patrolman McCoy's questioning, Mr. Mangione replied that it was raining and stated that he was going to let this all play out. ID. While Patrolman McCoy searched through a CVS bag on the table in front of Mr. Mangione, Mangione stated, calling a couple more cars, "This is a puffy jacket. I'm not very big." ID. At 9 hours, 44 minutes, and 4 seconds 9 hours, 44 minutes, and 9 seconds. Patrolman McCoy then removed the CVS bag from Mr. Mangione's table and placed it with the rest of his belongings. ID. At 9 hours, 44 minutes, and 9 seconds 9 hours, 44 minutes, and 14 seconds. At this point, there were 8 officers at the scene: Patrolman Fry, Patrolman McCoy, Patrolman Yeager and Corporal Miller were in the back of the McDonald's, while Patrolman Detwiller, Lieutenant Hanelli, Sergeant Burns and Corporal Trent were talking right outside. A 9th officer, Patrolwoman Christy Wasser, entered the back of the McDonald's a few seconds later, X6C at 9 hours, 44 minutes, and 45 seconds, with the 10th officer, Patrolman Stephen Fox, entering a minute later, X6E, 1 at 9 hours, 45 minutes, and 45 seconds. Given the police presence in the back of the McDonald's at the time, Lieutenant Hanelli noted at the hearing that he believed by 9:43 a.m. that the scene was under control and the situation was stable. HR 1001, see also HR 658-59. Patrolwoman Wasser testifying that the situation was at under control when Cha Orivid or the Martin Order 1, despite arriving at 9 hours, 44 minutes, and 45 seconds a.m., Patrolwoman Wasser did not turn on her body-worn camera until she started searching Mr. Mangione's backpack more than 13 minutes later. X6FJ at 9 hours, 58 minutes, and 5 seconds v. Detwiller re-entered the McDonald's at 9:45 a.m. There were 3 patrolmen surrounding Mr. Mangione, Fry, Yeager and McCoy, and Mr. Mangione's backpack was approximately 9 feet away on a table. HR 487, a distance that Lieutenant Hanelli testified at the hearing was adequate. HR 1009, notably, 2 of the patrolmen, Fry and Yeager, were positioned directly between Mr. Mangione and the backpack. 16, X6 a.m. 2 at 9 hours, 45 minutes, and 32 seconds. Given the distance between Mr. Mangione and the backpack, and the fact that officers were positioned between Mr. Mangione and the backpack, Sergeant Burns noted at the hearing that the scene was safe and that he felt secure that Mr. Mangione could not access the backpack. HR 1079, 1080. At 9:45 a.m., Lieutenant Hanelli called the turnkey officer on duty, Patrolman Austin Homan, and asked him to run Mr. Mangione's Rosario ID through NCIC, HR 961. At 9:46 a.m., with at least 10 officers now on the scene, Lieutenant Hanelli asked Patrolman Detwiller if read Mr. Mangione the false ID warnings required under Pennsylvania law. X6A, 2 at 9 hours, 46 minutes, and 46 seconds. When Patrolman Detwiller responded that he had not, Lieutenant Hanelli told Detwiller to provide Mr. Mangione with the required warnings. ID, at 9 hours, 46 minutes, and 57 seconds. Patrolman Detwiller then walked over to Mr. Mangione and informed him that he was under official police investigation and that he would be arrested for false ID if he gave the police a false name again. X6B, 1 at 9 hours, 46 minutes, and 59 seconds 9 hours, 47 minutes, and 10 seconds. Still without reading Mr. Mangione his Miranda rights, Patrolman Detwiller continued interrogating Mr. Mangione by asking if his name was Mark Rosario, to which Mr. Mangione responded, "No, sir." X6B, 1 at 9 hours, 47 minutes, and 10 seconds 9 hours, 47 minutes, and 14 seconds. Patrolman Detwiller asked Mr. Mangione for his real name and his date of birth, which Mr. Mangione provided to Patrolman Fry. ID, at 9 hours, 47 minutes, and 15 seconds 9 hours, 47 minutes, and 42 seconds. Patrolman Fox asked Mr. Mangione twice why he lied about his name. ID, at 9 hours, 47 minutes, and 43 seconds, 9 hours, 48 minutes, and 0 seconds. In response to this questioning, Mr. Mangione responded, "Clearly, I shouldn't have. X6A, 2 at 9 hours, 48 minutes, and 3 seconds. At this time, there were 10 officers surrounding Mr. Mangione and blocking his exit from the McDonald's. At 9 hours, 48 minutes, and 13 seconds AM, Patrolman Frick also asked Mr. Mangione why he lied, to which Mr. Mangione responded that it was the ID he had in his wallet. X6B, 1 at 9 hours, 48 minutes, and 13 seconds. Patrolman Fox then asked if Mr. Mangione had a fake ID, and Mr. Mangione replied, yes. X6B, 1 at 9 hours, 48 minutes, and 22 seconds. 6A, 2 at 9 hours, 48 minutes, and 25 seconds. At 9:48 AM, nearly 20 minutes after law enforcement first approached Mr. Mangione, prevented him from leaving, moved his property 9 feet away from him and asked him numerous interrogation questions. Corporal Trent instructed Patrolman Stephen Fox to finally read Mr. Mangione his Miranda warnings. X6G at 9 hours, 48 minutes, and 28 seconds. After informing Mr. Mangione of his constitutionally protected right to remain silent, Patrolman Fox asked Mr. Mangione if he wanted to talk to law enforcement. X6B, 1 at 9 hours, 48 minutes, and 51 seconds. Mr. Mangione exercised constitutional right to remain silent by first shaking his head no, and then stating, no, I don't think, clearly indicating that he did not want to speak to law enforcement. ID, at 9 hours, 48 minutes, and 55 seconds. 9 hours, 48 minutes, and 59 seconds. Patrolman Fox told Mr. Mangione that he was not in custody at this point. ID, at 9 hours, 48 minutes, and 55 seconds, despite the fact that, at that moment, there were 10 officers in the back of the McDonald's where Mr. Mangione was sitting. They had already decided with 100% certainty that he was the shooter, and he was clearly in custody and not free to leave. Despite Mr. Mangione exercising his right to remain silent, which Patrolman Fox had just told him was his right, Fox immediately continued to interrogate Mr. Mangione by asking why he had a fake ID. X6E, 1 at 9 hours, 49 minutes, and 33 seconds. After Mr. Mangione responded for the second time that he was going to remain silent. ID, at 9 hours, 49 minutes, and 37 seconds, Patrolman Fox ordered Mangione to stand and put his hands on the wall so Fox could pat him down. ID, at 9 hours, 49 minutes, and 56 seconds, to which Mr. Mangione complied in all respects. Patrolman Fox asked Mr. Mangione if he had any weapons on him, to which he initially responded, no. ID, at 9 hours, 50 minutes, and 6 seconds. After Patrolman Fox frisked Mr. Mangone's pockets and did not find anything, Mangione volunteered to Fox that he had a pocket knife in his right pocket. ID, at 9 hours, 50 minutes, and 14 seconds. At 9:50 AM, approximately 90 seconds after telling Mr. Mangione that he was not in custody despite being surrounded by officers, and after Mangione had been frisked twice, Sergeant Burns directed Patrolman Fox to handcuff and detain Mangione. X6G at 9 hours, 50 minutes, and 32 seconds, HR 791-92, 1044. Patrolman Fox put gloves on and then retrieved the pocket knife from Mr. Mangone's pocket and placed it on the table where Mangione was standing. X6C at 9 hours, 51 minutes, and 13 seconds. 9 hours, 51 minutes, and 22 seconds. Patrolman McCaw instructed Patrolman Fox to move the pocket knife to the adjacent table behind. At the hearing, Lieutenant Hanelli testified that Mr. Mangione was already detained at the 3.HR 1006.33 M, 4%. Is specified at the hearing that the knife was not illegal to carry in Pennsylvania. The wall of officers where McCoy had placed Mangone's backpack 9 minutes earlier. X6B, 1 at 9 hours, 51 minutes, and 26 seconds. Mr. Mangione remained standing, handcuffed and surrounded by officers as they waited to verify his identification. X.G.A., 2 at 9 hours, 50 minutes, and 50 seconds. At 9 hours, 51 minutes, and 37 seconds a.m., an investigator from the Pennsylvania Attorney General's office, Agent Andrew Christ, approached Mr. Mangione and took a photo of him, which he then sent to the FBI to run facial recognition on Mr. Mangione. X6B, 1 at 9 hours, 51 minutes, and 37 seconds, HR 1022. At 9:52 a.m., Patrolman Fox accused Mr. Mangione of giving a fake name again because law enforcement was not getting a response on the name Luigi Mangione. X6B, 1 at 9 hours, 52 minutes, and 2 seconds. Mr. Mangione stated that he provided the correct name, asked how Patrolman Fry had spelled his name and then the proper spelling, his date of birth, and that his ID was from Maryland. ID, at 9 hours, 52 minutes, and 2 seconds. 9 hours, 52 minutes, and 43 seconds. Mr. Mangione remained standing and handcuffed for the next 6 minutes while the Altoona Police Department reached out to the Blair County District Attorney's Office to decide how to proceed. HR 969-72. While waiting, Mr. Mangione asked why there were so many officers there. In response, Patrolman McCoy stated that there was just a lot of people trying to figure it out. X6B, 1 at 9 hours, 56 minutes, and 32 seconds. At 9:53 a.m., Lieutenant Hanelli first called the Blair County District Attorney Pete Weeks, but was unable to reach him and instead spoke with Assistant District Attorney Nicole Smith. X14. Lieutenant Hanelli explained the situation and asked ADA Smith whether it would be appropriate to charge Mr. Mangione with tampering with records or identification. HR 550-51. ADA Smith confirmed that the charge was appropriate and further advised Lieutenant Hanelli that a forgery charge was also justified. ID. Mr. Mangone's arrest and the searches at the McDonald's. The search of Mr. Mangione at 9 hours, 57 minutes, and 53 seconds a.m., Patrolman Detwiller approached Mr. Mangione to officially place him under arrest. X6B, 1 at 9 hours, 57 minutes, and 53 seconds. Before starting to search Mr. Mangione, Patrolman Detwiller moved Mangione closer to the table where Mangone's backpack had been placed 17 minutes earlier. X6C at 9 hours, 57 minutes, and 57 seconds. Patrolman Fry and Yeager still remained between Mr. Mangione and the table with his backpack. ID, at 9 hours, 58 minutes, and 1 second. This closer distance between Mr. Mangione and the backpack did not concern Lieutenant Hanelli because he did not believe it was plausible that Mr. Mangione could access the bag while rear-cuffed. HR 1010. Similarly, Patrolman Fox was unable to read Patrolman Fry's handwriting, which led to confusion about the proper spelling. However, body-worn camera footage and witnesses confirm that Mr. Mangione had given a proper spelling of his name and date of birth clear. Man McCoy noted at the hearing that he was not concerned that Mr. Mangione could access his backpack while rear-cuffed and surrounded by officers who had good body positioning. HR 1153-54. At 9 hours, 58 minutes, and 7 seconds a.m., Patrolman McCoy advised the Blair Dispatch Center to mark Mr. Mangione in custody. X6C at 9 hours, 58 minutes, and 7 seconds. At 9 hours, 58 minutes, and 29 seconds a.m., Patrolman Detwiller, Fry and McCoy started searching through Mr. Mangone's pockets and clothing. X6C at 9 hours, 58 minutes, and 29 seconds. From this search, the officers recovered a jar of peanut butter, a pouch with money, coins, gloves, papers, a hat and a rolled-up piece of string. HR 254-55. At 10 hours, 0 minutes, and 45 seconds a.m., Patrolman Detwiller and Fry removed Mr. Mangione from the McDonald's to bring him to the precinct. X6B, 1 at 10 hours, 0 minutes, and 45 seconds. On the drive to the precinct, Mr. Mangione asked Patrolman Fry and Patrolman Detwiller for their names and apologized for wasting their time. X6A, 3 at 10 hours, 2 minutes, and 57 seconds to 10 hours, 3 minutes, and 14 seconds. 2. The search of Mr. Mangone's backpack as Patrolman Detwiller approached to arrest Mr. Mangione. Patrolwoman Wassler simultaneously started walking over 10 search Mr. Mangone's backpack. X6B, 1 at 9 hours, 57 minutes, and 53 seconds. As established through the hearing testimony, By this time, law enforcement was confident that they had secured the back area of the McDonald's and that the situation was under control. See, for example, HR 1007 Lieutenant Hanelli testifying that he didn't see a need to clear the McDonald's of the customers because he had the situation under control. HR 1079, 1080, Sergeant Burns testifying that he felt the scene was safe at the point, and that there was plenty enough officers there to maintain scene security. HR 1084, Sergeant Burns testifying that the back of the McDonald's was secure. HR 338, Patrolman Detwiller testifying that, as of 9 hours, 48 minutes, and 50 seconds AM, the scene was under control. That law enforcement was in control of the area is further established by the fact that officers allowed McDonald's employees and customers to walk through the back area of the McDonald's throughout the entire time Mr. Mangione was surrounded by officers. X6B, 1 at 9 hours, 32 minutes, and 10 seconds employee accessing closet, 9 hours, 39 minutes, and 38 seconds employee accessing closet, 9 hours, 43 minutes, and 21 seconds employee accessing closet, 9 hours, 45 minutes, and 13 seconds customer using bathroom, 9 hours, 48 minutes, and 51 seconds customer using bathroom, 9 hours, 53 minutes, and 11 seconds customer using bathroom, 9 hours, 54 minutes, and 24 seconds. Employee using bathroom, X6A, 2 at 9 hours, 52 minutes, and 5 seconds. Patrolman Detwiller walking a customer out the back entrance. See also HR 338. Patrolman Detwiller testifying that he was not worried about customers using the bathroom because the place was under control. HR 1044. Sergeant Burns testifying that there were obviously a number of us. We were trying to secure that area, but we're allowing people to utilize the restroom as well as enter and exit the door there to the right. Nor did officers ever clear any part of the McDonald's of customers or employees the entire time they were there. At 9 hours, 58 minutes, and 12 seconds AM, Patrolman Fox approached the table with the backpack and asked Mr. Mangione if there was anything in the bag that they needed to know about. X6B, 1 at 9 hours, 58 minutes, and 12 seconds, HR 804. In response, Mr. Mangione stated that he would remain silent. IA. Notably, by the time Patrolman Fox asked Mr. Mangione that question, Patrolwoman Wasa had already put gloves on to begin the search of Mangione's backpack. X6C at 9 hours, 58 minutes, and 0 seconds, HR 673. Patrolwoman Wasa acknowledged that she had already intended to search the backpack even before hearing Mr. Mangione's response. HR 673. At 9 hours, 58 minutes, and 25 seconds AM, Patrolwoman Wasa and Patrolman Fox began their warrantless search of Mr. Mangione's backpack. X6C at 9 hours, 58 minutes, and 25 seconds. As part of this search, Patrolwoman Wasa and Patrolman Fox opened Mr. Mangione's backpack and started searching the backpack, its compartments and its contents, including multiple clothes bags and containers that were within the backpack, while Mangione stood handcuffed and surrounded by officers who were positioned between Mangione and his backpack. X60 at 9 hours, 58 minutes, and 49 seconds. At the time of Mr. Mangione's arrest and the search of his backpack, there were 12 law enforcement officers in the back of the McDonald's. 1. Patrolman Detwiller. 2. Patrolman Fry. 3. Patrolman McCoy. 4. Patrolman Yeager. 5. Patrolman Fox. 6. Patrolwoman Wasa. 7. Corporal Miller. 8. Corporal Trent. 9. Sergeant Dustin Thompson. 10. Sergeant Burns. 11. Lieutenant Hanelli. And 12. Agent Christ from the Pennsylvania Attorney General's office. Agent Christ entered the McDonald's at 9 hours, 49 minutes, and 31 seconds AM, as shown on the McDonald's surveillance video. X4B at 9 hours, 49 minutes, and 31 seconds. 2 additional officers from Altoona Police Department, Patrolmen Matthew Mazzara and Thomas Wendt, entered the McDonald's at 9 hours, 54 minutes, and 21 seconds AM, but left a few minutes later. X6B, 1 at 9 hours, 54 minutes, and 21 seconds. X4C at 9 hours, 59 minutes, and 4 seconds. The hearing testimony established that, at the time of the backpack search, the officers had the entire area under control. See, for example, HR 315, 320, 338, Patrolman Detwiller testifying that they were in control of the whole McDonald's as early as 9 hours, 30 minutes, and 38 seconds AM, and that he was not worried about letting customers use the bathroom. HR 658-59. Patrolwoman Wasa testifying that the situation was totally under control when she arrived at the McDonald's. HR 865-66. 874, Patrolman Fox testifying that the back area was controlled. FR 1001, 1005, 1007, 1018, 1021. Lieutenant Hanelli testifying that the scene was stable and completely under control. HR 1156. Patrolman McCoy testifying that when they got there, they established control. Moreover, Mr. Mangione had been compliant with law enforcement's requests and had not caused any issues at the McDonald's. HR 320, 354-55. Patrolman Detwiller testifying that Mr. Mangione was cooperative, was not giving him a hard time, and was not fighting or struggling. HR 521-22. Patrolman Fry testifying that Mr. Mangione never acted belligerent, didn't argue with the police, didn't fight with any officers, never reached for his backpack, and didn't ever reached for the pocket knife in his pocket. HR 886-919-20. Patrolman Fox. Mr. Mangione was polite the whole time, was compliant, followed his instructions, was never belligerent, never argued, never reached for a bag, and never reached for his pocket knife. 1017-18. Lieutenant Hanelli testifying that Mr. Mangione was cooperative as the law requires him to be and was not combative. HR 1078. Sergeant Burns testifying that there was no security concern leaving Mr. Mangione with 3 junior officers even though he was not handcuffed because Mr. Mangione was being compliant. HR 1154-56. Patrolman McCoy testifying that in Joan of the actions Mr. Mangione took that day were frightening or made him fear for his life, and that Mr. Mangione never acted belligerent, was never combative, never argued with the police, didn't fight with any officers, never tried to open his backpack, never reached for his backpack, and never reached into his pocket to get a pocket knife. At 9 hours, 58 minutes, and 50 seconds AM, just seconds after they opened the backpack, Corporal Trent approached Patrolwoman Wasa and Patrolman Fox and asked, "Why don't we go through this back at the station?" while making a comment referencing bombs. X6E, 1 at 9 hours, 58 minutes, and 50 seconds. Patrolwoman Wasa and Patrolman Fox briefly paused their search, and Patrolwoman Wasa responded, "One don't know. That's why we want to make sure there's nothing in there that's gonna ID 6E, 1 at 9 hours, 58 minutes, and 54 seconds. As Corporal Trent walked away, Patrolwoman Wasa and Patrolman Fox resumed their search of Mr. Mangione's backpack. Though purportedly still concerned about a possible bomb, Patrolman Fox joked he would rather have a bomb here than down at the station. ID at 10. Patrolwoman Wasa testified that Corporal Trent asked her about taking the bag back to the station, but also told her to check it for bombs. HR 587. Corporal Trent's full statement is unintenable on the body-worn camera. 9 hours, 59 minutes, and 0 seconds. Patrolwoman Wasa responded, laughing, "I don't want to pull a Moser ID." At 26, 27, 28 at 9 hours, 59 minutes, and 5 seconds AM, Patrolman Fox pulled a red journal from the Eagle Creek pouch found within Mr. Mangione's backpack and placed it on the table. X6E, 1 at 9, 59 minutes and 5 seconds. At 9 hours, 59 minutes, and 11 seconds AM, Patrolwoman Wasa recovered a waterproof bag, purported Faraday bag, ID, at 9 hours, 59 minutes, and 11 seconds. Just 15 seconds later, Patrolman Fox retrieved a small cardboard container from the backpack and struggled to slice it open with a knife. ID, at 9 hours, 59 minutes, and 26 seconds. When asked at the hearing whether he believed the cardboard contained a bomb, Patrolman Fox testified, knowing that he believed it contained some type of dollar chip. HR 893, at 9 hours, 59 minutes, and 30 seconds AM, patrolwoman Wasser opened and then removed a cell phone and passport from the black waterproof bag found within Mr. Manganeur's backpack. X6E, 1 at 9 hours, 59 minutes, and 30 seconds. Patrolwoman Wasser stated, "Got names in there," as she handed the passport to Sergeant Brian Miller ID, at 9 hours, 59 minutes, and 35 seconds. 9 hours, 59 minutes, and 40 seconds. After receiving the passport, Corporal Miller, Corporal Trent and Sergeant Burns inspected its contents. X60 at 9 hours, 59 minutes, and 48 seconds. Like Patrolman Fox, Patrolwoman Wasser acknowledged at the suppression hearing that she did not believe there could be a bomb inside the small bag, HR 679. Nevertheless, she opened the bag and removed both the phone and passport inside before giving it to other officers. X6E, 1 at 9 hours, 59 minutes, and 24 seconds. 9 hours, 59 minutes, and 39 seconds. At 9 hours, 59 minutes, and 44 seconds AM, 14 seconds later, Patrolwoman Wasser removed and searched a second item, his wallet, that she again acknowledged she knew did not contain a bomb. HR 687, she took out and examined 2 of Mr. Manganeur's credit cards before returning them to the wallet and then to the black waterproof bag. X6E, 1 at 9 hours, 59 minutes, and 44 seconds. Patrolwoman Wasser testified that the phrase "pull a Moser" referred to an incident in which an Altoona police officer named Moser brought a bomb back to the police station. HR 588. 10 hours, 0 minutes, and 36 seconds AM, Patrolwoman Wasser found and removed a chase envelope from Mr. Mangone's backpack, also too small to contain a bomb, which she examined before returning it to the backpack. X6E, 1 at 10 hours, 0 minutes, and 36 seconds. For more than 1 minute, Patrolman Fox continued cutting through the cardboard while supposedly searching for a bomb, despite acknowledging that he knew there was no bomb inside the cardboard. X6E, 1 at 10 hours, 0 minutes, and 51 seconds, 2 at 10 hours, 0 minutes, and 51 seconds AM, Patrolman Fox finally sliced open and revealed the computer chip enclosed in the cardboard container. ID. The officers continued their warrantless search through Mr. Mangone's backpack at McDonald's even after he was removed from the restaurant by other officers and had been driven to the precinct. Both Patrolwoman Wasser and Patrolman Fox continued to indiscriminately rummage through the backpack and its contents, during which they recovered a gun magazine loaded with bullets wrapped in a pair of underwear. ID. At 10 hours, 1 minute, and 7 seconds. After Patrolwoman Wasser excitedly announced her discovery of the magazine to the other officers in McDonald's, Corporal Trent promptly stated, "Now that you've cleared it all, let's just go back to the station." X6EL at 10 hours, 1 minute, and 31 seconds. Despite having just conducted an evidentiary search of the backpack including searching items that she knew did not contain a bomb, Patrolwoman Wasser responded that she was just making sure there wasn't a bomb or anything. ID. At 10 hours, 1 minute, and 33 seconds. Echoing Corporal Trent, Patrolman Fox told Patrolwoman Wasser, "Now that we found that is, the magazine, let's just lake it back." ID. At 10 hours, 1 minute, and 48 seconds. Although she had not completed 12, while Patrolwoman Wasser and Patrolman Fox were conducting their warrantless search of Mr. Mangone's backpack, Lieutenant Hanelli, at 10:01 AM, was placing his third call to the NYPD. Search of the backpack, Patrolwoman Wasser stopped searching and placed the items back into the bag, IA at L0VL. L, in addition to not calling for the bomb squad, evacuating the McDonald's or fully searching the backpack for an explosive device, the officers' lack of concern about a possible bomb was further evidenced when they began joking about it. At 10 hours, 1 minute, and 37 seconds AM, Agent Chris joked about blowing up Sergeant Thompson and Patrolman Fox laughed about blowing up his K9, Blue, X6E, 1 at 10 hours, 1 minute, and 37 seconds. 10 hours, 1 minute, and 45 seconds. At 10 hours, 3 minutes, and 7 seconds AM, while still inside the McDonald's, Patrolwoman Wasser, Patrolman Fox, Patrolman McCoy, Agent Christ, Sergeant Burns and Corporal Trent discussed whether they needed to obtain a search warrant before continuing their search of the bag. Patrolwoman Wasser again claimed that she searched the backpack to make sure there's no bombs. X6E, 1 at 10 hours, 3 minutes, and 28 seconds. In response, Corporal Trent stated that, at this point, you're probably gonna need to do a search warrant for the backpack, and instructed Patrolwoman Wasser and Patrolman Fox to just leave the backpack when they arrived at the station. ID, at 10 hours, 3 minutes, and 30 seconds. 10 hours, 3 minutes, and 44 seconds. Sergeant Burns responded that Mr. Mangione was being arrested for a crime in Pennsylvania and that they could therefore search the backpack incident to arrest. ID, at 10 hours, 3 minutes, and 43 seconds. While Patrolman Fox agreed with Sergeant Burns, Corporal Miller echoed Corporal Trent's sentiments, stating that they needed 13. Patrolwoman Wasser testified that she looked and felt inside the backpack one more time and was satisfied that there was no bomb. HR 392, J99-600. It is unclear how Patrolwoman Wasser felt comfortable there was no bomb when she did not finish searching her section of the backpack. Patrolman Fox did not finish searching his section of the backpack, and there was a third compartment of the backpack that no one had searched. HR 697. Patrolwoman Wasser admitting that she did not open the other compartments and that she did not even reach down to search TH Street of the middle compartment she had been searching. Moreover, Patrolwoman Wasser's declared she felt comfortable that she had sufficiently searched the backpack for a bomb is shown 1. Be even more absurd given that, once at the precinct, Wasser found a silencer, an object the shape and size of a pipe bomb in the very section where she had searched, and then stopped searching. A search warrant for the backpack. ID, at 10 hours, 4 minutes, and 0 seconds. After this discussion, Patrolman Fox left the McDonald's at 10 hours, 4 minutes, and 13 seconds AM carrying a brown McDonald's bag containing some of the contents of Mr. Mangione's backpack, which he then placed in the back of his vehicle. X6E, 1 at 10 hours, 4 minutes, and 13 seconds. 10 hours, 4 minutes, and 40 seconds. Patrolwoman Wasser left the McDonald's at the same time carrying Mr. Mangione's backpack and told Patrolman Fox that she would see him at the station. X6F, 1 at 10 hours, 4 minutes, and 13 seconds. Patrolwoman Wasser shut off her body-worn camera as she walked towards her car. Although she was about to start driving to the precinct, Patrolwoman Wasser kept wearing the disposable gloves that she had put on in order to search Mr. Mangione's backpack. After Patrolwoman Wasser and Patrolman Fox left, Lieutenant Hanelli, Sergeant Burns, Corporal Miller, Sergeant Thompson, Corporal Trent and Agent Christ remained inside the McDonald's. X4B at 10 hours, 3 minutes, and 57 seconds. 10 hours, 5 minutes, and 57 seconds. At 10:06 a.m., while still there, Lieutenant Hanelli received a call from Deputy Chief Derek Swope. X4B at 10 hours, 6 minutes, and 4 seconds. X14. At 10:09 a.m., Lieutenant Hanelli, Corporal Trent, Sergeant Burns, Agent Christ and Corporal Miller left the McDonald's while Sergeant Thompson stayed behind to collect information from customers and a McDonald's employee. X4B at 10 hours, 9 minutes, and 7 seconds. See the Searches at the Precinct. The search of Mr. Mangione. Patrolman Detwiller and Fry arrived with Mr. Mangione at the precinct at 10 hours, 10 minutes, and 28 seconds AM, taking them less than 9 minutes to drive from the McDonald's. X6B, 2 at 10 hours, 10 minutes, and 28 seconds, HR 354. Both hearing testimony and camera footage confirm that this approximately 9-minute drive was at a normal speed, without lights and sirens, and included stopping at one traffic light that took 1 minute and 41 seconds before it turned green. In the intake area of the precinct, Patrolmen Fry and Homan processed Mr. Mangione's arrest and inventoried the property they recovered. 30 from his person. X6B, 2 at 10 hours, 12 minutes, and 1 second. 10 hours, 20 minutes, and 40 seconds. X6B, 3 at 10 hours, 22 minutes, and 24 seconds. 10 hours, 25 minutes, and 42 seconds. Mr. Mangione was shackled by his ankle with his hands uncuffed while he answered pedigree questions. ID. Mr. Mangione removed his extra layers of clothing as directed. Mr. Mangione was also strip searched before being taken to a cell. X6B, 3 at 10 hours, 26 minutes, and 54 seconds. The search of Mr. Mangone's backpack after patrolwoman Wasa left the McDonald's at 10 hours, 4 minutes, and 13 seconds a.m. There is no body-worn or car camera footage from her for the next 11 minutes as patrolwoman Wasa drove to the precinct with the backpack. When patrolwoman Wasa arrived at the precinct at 10 hours, 15 minutes, and 7 seconds a.m., she was still wearing the rubber gloves and had possession of both the backpack and the brown McDonald's bag that patrolman Fox had placed in his car. X6F, 2 at 10 hours, 15 minutes, and 7 seconds, 14 as patrolwoman Wasa exited her vehicle, she turned on her body-worn camera that she had shut off when leaving the McDonald's. HR 715, at 10 hours, 15 minutes, and 37 seconds a.m., patrolwoman Wasa entered the precinct's intake area where Mr. Mangione was being processed by patrolmen Fry and Homan. X6F, 2 at 10 hours, 15 minutes, and 37 seconds. Patrolwoman Wasa set Mr. Mangone's backpack on a chair located in the corner of the precinct's intake area and placed the McDonald's bag on the floor nearby. ID, at 10 hours, 16 minutes, and 6 seconds. As depicted in the picture below, there was no room in this area for patrolwoman Wasa to remove 14. Patrolwoman Wasa testified at the hearing that she met patrolman Fox on the way to precinct to retrieve the McDonald's bag from Fox because he was called back to the McDonald's. HR 601, patrolwoman Wasa claimed that she could not remember how she communicated with patrolman Fox to arrange this meeting, whether she radioed him or called him on his cell phone, what they said to each other during this communication arranging the meeting, or whether they had any conversation when this transfer happened. HR 712-14. This interaction, for which there was no body-worn camera footage, lasted between 10-12 seconds, as per patrolman Fox. HR 829, or between about 30-40 seconds, as per patrolwoman Wasa. HR 713. Patrolwoman Wasa offered no explanation as to why it took her a full 2 minutes longer to arrive at the precinct than patrolman Detwiller and Fry. All the items from the backpack and conduct an inventory search. X6F, 2 at 10 hours, 16 minutes, and 3 seconds, at 10 hours, 16 minutes, and 8 seconds a.m., 1 minute after arriving at the precinct, just as she knew the audio on her body-worn camera would begin recording. Patrolwoman Wasa continued her warrantless search of the backpack. Patrolwoman Wasa initially reopened the same backpack compartment that she had already started searching at the McDonald's, but which she had never finished searching, before immediately closing that compartment while uttering something indecipherable, clearly indicating that she had mistakenly opened the wrong compartment. Patrolwoman Wasa then immediately opened the front compartment of the backpack, as if she was specifically looking for something. X6F, 2 at 10 hours, 16 minutes, and 9 seconds. Instantly, without having to search or rummage through the front compartment at all, she found a handgun in full view of her body-worn camera. IS patrolwoman Wasa testified that it takes a minute before the body-worn camera sound is activated. HR 689, finding the gun at the precinct, allegedly for the first time, and moving the backpack and McDonald's bag to a different location away from Mr. Mangione. Patrolwoman Wasa again explained to Deputy Chief Swope that she quickly searched the bag at McDonald's to make sure there were no bombs or anything. X6F, 2 at 10 hours, 17 minutes, and 0 seconds. Patrolwoman Wasa did not explain why she did not seek a warrant once she had arrived at the precinct, despite clear instructions from Corporal Trent and Corporal Miller, both of whom are her superiors, to do so. Patrolwoman Wasa then continued to search the backpack at the precinct, on the floor of the hallway, without a warrant. The video and audio of this search clearly shows that this was not an inventory search. In fact, not only was she searching for evidence, Patrolwoman Wasa was specifically looking for Mr. Mangone's identification, which she initially could not find, but continued to rummage around the backpack indiscriminately until she was able to locate it. As part of this search, Patrolwoman Wasa removed evidentiary items from the backpack and placed them in separate evidence bags, including the following: a gun, X6F, 2 at 10 hours, 18 minutes, and 4 seconds, a microchip, 10 hours, 18 minutes, and 9 seconds, a cell phone and a Faraday bag, 10 hours, 18 minutes, and 32 seconds, a silencer, 10 hours, 19 minutes, and 26 seconds, the knife that Patrolman Fox removed from Mr. Manganeur's pocket, 10 hours, 19 minutes, and 43 seconds, a gun magazine, 0 hours, 22 minutes, and 18 seconds, a red journal, 10 hours, 22 minutes, and 50 seconds. The hearing testimony established that members of the Altoona Police Department were in constant contact with the NYPD, and that they deemed all of Mr. Manganeur's property as evidence because this was a homicide investigation and everything was going to be surrendered in the NYPD. SB, 10 hours, 23 minutes, and 40 seconds, SIM cards, 10 hours, 23 minutes, and 38 seconds, a camera, 10 hours, 26 minutes, and 3 seconds, and a piece of paper with directions, 10 hours, 27 minutes, and 46 seconds. After removing these items and placing them in separate evidence bags, Patrolwoman Wasser asked if she should put this all back in, referring to the other items that she had recovered from the backpack, but had not yet separated as evidence. X6F, 2 at 10 hours, 28 minutes, and 19 seconds. An officer replied that she should, and she then placed all the other items back into the backpack without taking any inventory of these items, which included a bag of toiletries, with some pills, batteries, items of clothing, masks and hair clips. At no point during this evidentiary search did Patrolwoman Wasser, Deputy Chief Swope, Sergeant Burns or any other Altoona officer who entered the area document or catalogue the items being removed from or returned to the backpack. At 10:25 a.m., Lieutenant Hanelli spoke for roughly 15 minutes with NYPD officers and detectives and provided information regarding Mr. Manganeur's arrest, which included discussing evidence that had been recovered from Manganeur, X14, HR 981. While on the known with NYPD, Lieutenant Hanelli missed a call from ADA Smith at 10:34 a.m., X14, HR 981-82, at 10 hours, 26 minutes, and 54 seconds a.m., Patrolman Fry and 3 additional officers escorted Mr. Manganeur from the intake area to holding cell 2, X6B, 3 at 10 hours, 26 minutes, and 54 seconds, at 10 hours, 31 minutes, and 12 seconds a.m. Patrolman Fry returned to the intake area, where Patrolman Fox, Patrolman Homan, Sergeant Houston, Patrolman George Featherstone and Sergeant Thompson were standing with the items recovered from Mr. Manganeur's person, X6B, for at 10 hours, 31 minutes, and 12 seconds, at 10 hours, 32 minutes, and 11 seconds a.m., as Patrolman Fry began placing the items found on Mr. Manganeur's person into a Brownlow's bag. Fry asked Patrolman Homan. He had documented everything of evidentiary value, ID, at 10 hours, 32 minutes, and 11 seconds. At the suppression hearing, Patrolman Fry testified that, notwithstanding the Altoona Patrol Guide's explicit requirement that officers inventory all property, he was only concerned about the evidence that was of an evidentiary nature, while he and Patrolman Homan placed Mr. Manganeur's items into evidence bags. HR 518-19, at 10 hours, 33 minutes, and 52 seconds a.m., while still in the intake area, Sergeant Houston received a phone call from Sergeant Venius of the NYPD, X6B, for at 10 hours, 33 minutes, and 52 seconds, HR 1236. Sergeant Houston told Sergeant Venius that Mr. Manganeur was more likely than not the CEO shooter, stating they found all kinds of goodies. 6B, for at 10 hours, 33 minutes, and 52 seconds, 10 hours, 34 minutes, and 0 seconds. Sergeant Houston testified that by goodies he was referring to evidence that he thought would help the NYPD in their case. HR 1237. Sergeant Houston informed Sergeant Venius that they recovered a handgun, suppressor, a cell phone in a Faraday bag, and a checklist. X6B, for at 10 hours, 34 minutes, and 4 seconds, 10 hours, 34 minutes, and 25 seconds. Sergeant Houston stated that he was listing items that appeared to be of evidentiary value and that confirmed Mr. Mangione was more likely than not the shooter. HR 1237, at 10 hours, 32 minutes, and 22 seconds AM, after completing her warrantless search of Mr. Mangione's backpack in the hallway, patrolwoman Wasa returned to the intake area of the precinct with the backpack, the McDonald's bag and the Mark Rosario ID, X6B, for at 10 hours, 32 minutes, and 22 seconds. At the hearing, Patrolman Featherstone testified that the backpack was then moved from the intake area to a small office area down the hallway of the precinct. HR 1285. Patrolman Featherstone stated that he, Patrolwoman Wasa and Sergeant Houston later moved Mr. Mangione's items, both the backpack and the items found on Mr. Mangione's person, to his office once they realized that the original room was not going to be sufficient for them to conduct a search. ID. Patrolman Featherstone claimed that when Mr. Mangione's items were brought to his office, nothing was labeled and the ice dome items were placed inside envelopes essentially for transport, for storage, and were not really marked while others were still inside the backpack. HR 1286-87. At 10:45 a.m., Lieutenant Hanelli received a call from NYPD Lieutenant David Leonardi and informed him that Mr. Mangione had been placed under arrest for possession of the Mark Rosario fake ID. HR 1406-07. Based on the information Lieutenant Hanelli provided, Lieutenant Leonardi told Hanelli that it's possible that Mr. Mangione is the NYPD's person of interest, that he would like no one to speak to Mr. Mangione, and that all of Mr. Mangione's property should be held until Leonardi arrived in Altoona. HR 1407. At 10:58 a.m., Lieutenant Hanelli called ADA Smith, X14. 1 minute later, Lieutenant Hanelli received another phone call from Lieutenant Leonardi, ID. After speaking with Lieutenant Hanelli, Lieutenant Leonardi and his team left for Altoona, Pennsylvania. HR 1406 and 1407. Between approximately 10:30 a.m. and 10:40 a.m., all of Mr. Mangione's belongings were gathered in Patrolman Featherstone's office and Sergeant Houston began taking photographs of the items. HR 1232, 1287. About halfway through the search, Mr. Mangione's property was moved upstairs to the roll call or training room to allow additional agencies to come in. HR 1293, 1294. At approximately 10:46 a.m., Corporal Trent can be seen carrying the McDonald's bag and backpack through the rear corridor of the precinct, followed by Patrolwoman Wasa, Sergeant Burns and Patrolman Fox, X.H. In the roll call room, Patrolman Featherstone, Sergeant Burns and Sergeant Houston continued documenting Mr. Mangione's property. Sergeant Houston removed writings from Mr. Mangione's journal and various envelopes, read the contents of the writings and photographed the writings to send them to the NYPD. Sergeant Houston also photographed U.S. currency, a USB contained in a blue and black pouch, the Mark Rosario ID, a black wallet with U.S. currency, a SEPTA ticket, a Greyhound bus ticket, a Visa gift card, a USB drive attached to a chain, foreign currency, sneakers, gloves, jackets, an orange hat, clothing, a U.S. passport, a Maryland driver's license, a backpack, a gun, a suppressor, magazines, a computer chip enclosed in cardboard, an Eagle Creek pouch, a black and white pouch and Mr. Mangione's red journal, X8B, 18B, 39, HR 1287. From the moment he became involved, Sergeant Houston stated that he was ultimately helping the NYPD with their case. HR 1235. Though Sergeant Houston claimed he methodically catalogued the property, he read and selectively photographed only certain pages of the journal and items collected from the backpack that he thought were crucial to the NYPD's investigation. HR 1234-35, 1238. See also HR 1234, 1235, Sergeant Houston testifying that he read part of the journal and only photographed the pages that appeared pertinent to the NYPD's investigation. At approximately 12:15 p.m., Sergeant Houston emailed the photos he took of Mr. Manganeur's belongings to NYPD detectives, including photographs of the writings contained in the Red Journal, HR 1234. Similarly, Lieutenant Hanelli sent photos of the journal, laptop, cell phone and other belongings recovered from Mr. Mangione to Detective Gunn and other NYPD detectives via text and email. HR 1012-16. Around 1:19 p.m., Sergeant Burns took additional photos of the seized property. HR 1102. Of the 172 photos that Sergeant Burns took, the majority depicted the writings from Mr. Manganeur's journal. HR 1101. As Sergeant Burns was flipping through, he testified that he read some of the journal just out of curiosity and saw pages labeled blog and others with miscellaneous writings. HR 1101-02. Like Sergeant Houston, Sergeant Burns stated that he was not taking pictures of the journal for the purposes of the Altoona forgery case, but was instead taking them for the New York City investigation of the shooting. HR 1102-1103. See also HR 1103. Sergeant Burns testifying that he was taking pictures for what may be relevant to New York City investigation. Sergeant Burns later provided the photographs to the FBI, Homeland Security and Pennsylvania State Police. HR 1108. Again, Sergeant Burns stated that providing the photos to various law enforcement agencies had nothing to do with the Altoona forgery investigation and everything to do with the New York City investigation into the shooting ID. Further, Sergeant Burns confirmed that all these searches were done before and without any search warrant ID. At 4 hours, 40 minutes, and 20 seconds p.m., Sergeant Dustin Thompson escorted Mr. Mangione from holding cell 2 to an interview room in the precinct where he met with ADA Joel Seidelman, Detective Oscar Diaz and Detective James Curcio, X6A at 16 hours, 40 minutes, and 20 seconds. After reading Mr. Mangione his Miranda warnings at 4 hours, 40 minutes, and 53 seconds p.m., ADA Seidelman, Detective Diaz and Detective Curcio attempted to question Mr. Mangione for approximately 5 minutes before exiting the interview room at 4 hours, 46 minutes, and 6 seconds p.m., leaving Mr. Mangione alone until 4 hours, 59 minutes, and 29 seconds p.m. ID, at 16 hours, 40 minutes, and 53 seconds 16 hours, 59 minutes, and 29 seconds. Although there were no law enforcement personnel in the room, officers continued to surreptitiously record Mr. Mangione in the room alone even though Pennsylvania is a two-party recording state. HR 1433-34. Mr. Mangione was then returned to his holding cell. Over 7 hours after the warrantless search of Mr. Manganeur's backpack, the Altoona Police Department finally sought a search warrant at 5:14 p.m., which Sergeant Houston prepared and ADA Smith approved. X12A, HR 564. This warrant application sought permission for the NYPD to seize Mr. Manganeur's backpack and other belongings from Altoona law enforcement. The following day, Sergeant Houston prepared a second search warrant to allow the NYPD to seize Mr. Manganeur's clothes, which DA Pete Wicks approved at 12:07 p.m. X12B. The District Attorney's Office had originally informed counsel that it intended on using Mr. Manganeur's statements while alone in the interview room at trial. The prosecutors withdrew their statement notice after this testimony revealed the legal nature of the recording. 5 hours, 33 minutes, and 8 seconds p.m., Patrolman Fry and Patrolman Fox escorted Mr. Mangione from the Altoona Police Precinct to the Blair County Courthouse for his preliminary arraignment. X6B, 5 at 17 hours, 33 minutes, and 8 seconds p.m. During the drive, Mr. Mangione commented that Altoona is a nice town and that the Mcdonald's on Plank Road was a community center. X6E, 2 at 5 hours, 38 minutes, and 16 seconds 5 hours, 38 minutes, and 40 seconds. Patrolman Frick, Patrolman Fox and Mr. Mangione arrived at the courthouse at 5 hours, 50 minutes, and 9 seconds p.m. for his 6:30 p.m. appearance. X6B, 5 at 17 hours, 50 minutes, and 9 seconds, H.R. 557. In the courthouse, Patrolman Fox alleged that Mr. Mangione stated, "All of these people here defending a mass murderer, that's wild," referring to the reporters at the courthouse. Apostrophe. R 831-32, 917-18. A fear the arraignment, Mr. Mangione was taken to the State Correctional Institution in Huntingdon, SCI Huntingdon, located approximately 45 minutes from the Blair County Courthouse. H.R. 566, from December 9, 2024, to December 19, 2024, Mr. Mangione was housed at SCI Huntingdon under constant watch. X15, Mangione Monitoring Form, HR 8182. Corrections Officer Thomas Rivers testified that they were required to complete a close watch form where they wrote down Mr. Mangone's physical movements approximately 7 times an hour. ID. While observing Mr. Mangione, corrections officers sat approximately 2 meters away from his cell. HR 136. Corrections Officer Matthew Henry was tasked with monitoring Mr. Mangione on December 10, 11, 12 and 13, 2024. HR 135-36. CO Henry testified that on December 10, 2024, Mr. Mangione blurted out statements to him, without any prompting or questioning. HR 147. CO Henry stated that Mr. Mangione told him about the foreign currency, the 3D printed pistol found in his backpack, that he was being accused of being a foreign agent, that he was arrested in McDonald's by one older and one younger officer, and that he was a software engineer. HR 136-38, 147. According to CO Henry, Mr. Mangione volunteered all this information. 18. There is no body-worn camera footage of this alleged statement. HR 917. CO Henry initiating, responding to or participating in the conversation in any way. ID. Further, CO Henry stated he did nothing to memorialize what Mr. Mangione said. He did not write anything down, make a recording or note it in his phone despite knowing that Mr. Mangione was a suspect in a gun-related murder case in New York City. HR 149-51. CO Henry testified that he could not recall any other conversations with Mr. Mangione on December 11th, 12th, or 13th, 2024, HR 138-39, on December 16th, 2024, Corrections Officer Rivers monitored Mr. Mangione between approximately 1:30 p.m. and 9:30 p.m., HR 86-94. Without CO Henry initiating, responding to or participating in the conversation in any way. ID. Further, CO Henry stated he did nothing to memorialize what Mr. Mangione said. He did not write anything down, make a recording or note it in his phone despite knowing that Mr. Mangione was a suspect in a gun-related murder case in New York City. HR 149-51. CO Henry testified that he could not recall any other conversations with Mr. Mangione on December 11th, 12th, or 13th, 2024, HR 138-39, on December 16th, 2024, Corrections Officer Rivers monitored Mr. Mangione between approximately 1:30 p.m. and 9:30 p.m., HR 86-94. CO Rivers testified that, during that time, Mr. Mangione talked about his travels, different mental states within third world countries compared to the West, and asked CO Rivers his opinion on healthcare. HR 87-89. CO Rivers stated that he could not recall who initiated the conversation about healthcare or specifically remember what he said to Mr. Mangione, but that he did offer his opinion on the differences between private and naturalized healthcare. HR 88-89. Towards the end of his shift, CO Rivers claimed that Mr. Mangione asked him about his public perception on mainstream media versus social media. HR 89-90. In addition, CO Rivers claimed that Mr. Mangione made comments about being compared to Ted Kaczynski, but could not recall any details about how Kaczynski was brought up. HR 1991. CO Rivers also testified that Mr. Mangione asked to make a public statement and asked about the media's focus on the case. HR 91-92. CO Rivers testified that, the following day, December 17, 2024, he was assigned to monitor Mr. Mangione again. HR 94-95. C.O. Rivers stated that he and Mr. Mangione discussed literature, including authors Orwell, Huxley and Thoreau, and that Mr. Mangione recommended The Doors of Perception by Huxley, H.R. 95. At some point, C.O. Rivers stated that Mr. Mangione brought up American health and that they discussed the standard of health among Americans and compared them to Europeans, H.R. 96. Like C.O. Henry, however, C.O. Rivers did not take any notes or write down any part of their many conversations, except for the book recommendation of The Doors of Perception, H.R. 127, 3. Argument A. All evidence recovered from Mr. Mangone's backpack must be suppressed because law enforcement failed to obtain a search warrant before searching the backpack. 1. Legal standard New York law applies although the statements and evidence that Mr. Mangione seeks to suppress were obtained by Altoona law enforcement in the Commonwealth of Pennsylvania. Mr. Mangione is being prosecuted in New York State for a crime that he allegedly committed in New York. Under these circumstances, there can be no doubt that New York is the forum state. Accordingly, New York law applies to the suppression issues in this case because New York has a paramount interest in the application of its law where it is the forum state. See, for example, People v. Espinal, 161 AD, 3D 556, 557 A Step 2018, we find it unnecessary to decide any questions of New Jersey search and seizure law, because we find that New York law governs the issues raised here. Suppression issues, including those arising out of a defendant's constitutional rights, are generally governed by the law of the forum, and New York has a paramount interest in the application of its laws to this case. Quotation omitted. People v. Lerau, 70 AD 3D 66, 70, 4th Dep 2009. We note at the outset that the people are correct that New York law applies to the administration of defendant's blood test because procedural and evidentiary issues are governed by the law of the forum state, and New York has a paramount interest in the application of its laws to this case. Citations and quotations omitted. People v. Johnson, 303 AD, 2D 903, 904, 3D Dep 2003, applying New York law in a criminal case pending in New York because procedural and evidentiary issues are governed by the law of the forum. People v. Sebulist, 206 AD, 2D 901, 901, 4th Dep 1994. County Court properly concluded that New York law applies to the custodial interrogation of a 16-year-old Pennsylvania resident conducted by members of the New York State Police in a Pennsylvania police station concerning the suspect's involvement in a homicide committed in New York. People v. Ostis, 179 AD, 2D 893, 894, 3D Dep 1992. Although defendant's oral statement was taken in Indiana by Indiana police officers, it was to be used in a New York criminal proceeding generated by a violent crime committed in New York. Hence, New York has a paramount interest in applying its laws. People v. Benson, 88 AD 2D 229, 231, 1982. Traditionally, procedural and evidentiary issues are governed by the law of the forum. Legal standard for searches incident to a lawful arrest in New York. The Fourth Amendment protects individuals from unreasonable searches and seizures by the government. U.S. Constable Amend. IV. Building on the Fourth Amendment's protections, the New York Court of Appeals has ruled that agile warrantless searches presumptively are unreasonable per se, and, thus, where a warrant has not been obtained, it is the people who have the burden of overcoming this presumption of unreasonableness. People Volume Jimenez, 22 NY, 3D 717, 721, 2014. Quotations and alterations omitted. See also People v. Jenkins, 24 NY, 3D 62, 64, 2014. S. Object only to carefully drawn and narrow exceptions. A warrantless search of an individual's home is per se unreasonable and hence unconstitutional. While New York courts have accepted a search conducted by law enforcement incident to a lawful arrest as an exception to the warrant requirement, the prosecution must first satisfy two separate requirements. The first imposes spatial and temporal limitations to ensure that the search is not significantly divorced in time or place from the arrest. The second, and equally important, predicate requires the people to demonstrate the presence of exigent circumstances. Jimenez, 22 NY, 3D at 721-22. See also People v. Goki, 60 NY, 2D 309, 312, 1983. Under the state constitution, an individual's right of privacy in his or her effects dictates that a warrantless search incident to arrest be deemed unreasonable unless justified by the presence of exigent circumstances. The exigent circumstances requirement for searches incident to a lawful arrest specifically applies when law enforcement searches closed containers. Jimenez, 22 NY, 3D at 719, in the context of warrantless searches of closed containers incident to arrest. The people bear the burden of demonstrating the presence of exigent circumstances in order to invoke this exception to the warrant requirement. When addressing the exigency requirement for a warrantless search incident to a lawful arrest of property within the defendant's immediate control or grabbable area, the Court of Appeals has recognized two interests that may justify the warrantless search of that property incident to a lawful arrest: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. Goki, 60 NY, 2D at 312, People v. Morales, 126 AD, 3D 43, 45 Step 2015. The Court of Appeals has recognized two interests underlying the exigency requirement: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. People v. Julio, 245 AD, 2D 158, 158 Step 1997. A bag that is within the immediate control or grabbable area of a suspect at the time of his arrest may not be subjected to a warrantless search incident to arrest unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence. Nevertheless, because the search incident to a lawful arrest extension to the warrant rule requires exigency, may not be searched for a weapon or evidence if it is apparent that it is so securely fastened that the person arrested cannot quickly reach its contents, or the person arrested makes unmistakably clear that he will not seek to reach the contents, or the container is so small that it could not contain a weapon or evidence of the crime. People v. Smith, 59 NY, 2D 454, 458, 1983. Citations omitted, ruling that the police did not need a warrant where at the time of arrest defendant was holding the briefcase in his hand. Its contents were, therefore, readily accessible to him and it was of sufficient size to contain a weapon. Similarly, even a bag within the immediate control or grabbable area of a suspect at the time of his arrest may not be subjected to a warrantless search incident to the arrest, unless the circumstances leading to the arrest support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. People Volume Jimenez, 22 NY, 3D at 722, People v. Washington, 171 AD, 3D 458, 459 Step 2019, we find that the trial court should have suppressed the 12-inch knife recovered by the police during a warrantless search of defendant's bag. Although at the time of the search the bag was on the floor within the grabbable area next to defendant, he was standing with his arms handcuffed behind his back. These circumstances do not support a reasonable belief that the defendant could have either gained possession of a weapon or destroyed evidence located in the bag. Internal Goki citation omitted. People v. Houston, 143 AD, 3D 737, 738-39, 2D Dep 2016, suppressing evidence recovered from the warrantless search of the defendant's briefcase that he placed on a parked car when he surrendered because, even though the police had found a loaded gun on the defendant's jacket pocket when they arrested him, the police failed to establish exigent circumstances to search case. Moreover, a search incident to a lawful arrest is not justified, and suppression is proper, when the defendant's backpack is not within the defendant's immediate control or grabbable area at the time he was arrested. See, for example, People v. Thompson, 118 AD, 3D 922, 924, 2D Dep 2014, suppressing a semi-automatic gun recovered from the defendant's backpack because the search was not justified as a search incident to a lawful arrest. As the backpack was not within the defendant's immediate control or grabbable area at the time he was arrested, People v. Diaz, 107 AD, 3D 401, 401 is Step 2013, warrantless search of the defendant's backpack was unlawful because the defendant was handcuffed at the time of the search and it was no longer in his control. People v. Julio, 245 AD, 2D 158, 158. Step 1997. Warrantless search of the defendant's bag was unlawful where it was in the exclusive control of the police and the defendant was unable to reach it because he was handcuffed and surrounded by police officers. People v. Morales, 126 AD, 3D 43 Step 2015, is particularly instructive. There, the police responded to a 911 call of a suspicious man inside a restaurant who appeared to be trying to steal from women's purses. After exiting the restaurant with the police, the defendant placed both of his hands in his jacket pockets, leading to a struggle between the officers and the defendant when the defendant refused to remove his hands from his jacket pockets. The 7 officers at the scene subdued the defendant, handcuffed him and placed him in a police car, while the defendant, degrees Celsius People v. Velez, 154 AD, 3D 527, 528 Step 2017, finding exigent circumstances to search the defendant's wallet, even though the defendant was handcuffed because the wallet was within his grabbable area and had not been reduced to the exclusive control of the police, and because the officers had reason to suspect that the wallet might contain a weapon, because defendant had been arrested for robbery, a violent crime, and the officers had already recovered one razor blade from defendant, in Remarkable H. 161 AD, 3D 459, 460. Step 2018, denying suppression where the bag was in appellant's grabbable area, and the police opened the bag almost simultaneously with handcuffing appellant. Handcuffed in the back seat, officers searched his jacket that had fallen onto the trunk of the police car during the altercation and found drugs and a box cutter. In reversing the lower court and dismissing the indictment, the First Department found that at the time of the search, the jacket was not within defendant's grabbable area, and there were no exigent circumstances justifying a warrantless search of the jacket incident to arrest. ID, at 44. While the defendant had struggled with the police earlier, the First Department noted that the defendant was subdued at the time of the search and that the scene at the time of the search was police-controlled. ID, at notably, in suppressing the evidence, the First Department rejected the dissenting judge's argument that the search was justified because the jacket may have contained a loaded gun that would endanger the police and the public because, even if there had been a legitimate concern, at some earlier time during the encounter between defendant and the police, that defendant might retrieve a weapon from the jacket, that possibility no longer existed at the time the police conducted the search. ID, at 48. The First Department further noted how the dissent's argument was not consistent with New York case law. Taken to its logical conclusion, the dissent is arguing that an exigency that may have existed earlier in the encounter allowed the police to search the jacket, even where the jacket was in the exclusive control of the police. That view, if accepted, would run afoul of Court of Appeals jurisprudence and would eviscerate the grabbable area doctrine. ID. See also ID, at 48-49. The dissent would extend this doctrine and hold that whenever there is the possible presence of a weapon, the police can search a container to protect themselves, even if it is nowhere near the suspect's grabbable reach. Such a conclusion finds no support in this state's jurisprudence on searches incident to arrest. For inventory searches in New York, an inventory search is exactly what its name suggests, a search designed to properly catalog the contents of the item searched. People v. Johnson, 1 NY, 3D 252, 256, 2003. See also People v. Douglas, 40 NY, 3D 385, 389, 2023. An inventory search is a search designed to properly catalog the contents of the item searched. Quoting Johnson, as the Supreme Court has stated, an inventory search must not be a ruse for a general rummaging in order to discover incriminating evidence. Johnson, 1 NY, 3D at 256, quoting Florida v. Wells, 495 U.S. 1, 4, 1990. See also People v. Walker, 20 NY 3D 122, 127, 2012, noting that police do not have carte blanche to conduct any search they want and call it an inventory search. Rather, B.J. course a warrant based on probable cause is not required to execute an inventory search. Any inventory search must be conducted according to a familiar routine procedure. Douglas, 40 NY 3D at 389, quoting People v. Gallic, 80 NY 2D 715, 719, 1993. This procedure must be designed to meet three specific objectives: to protect the property of the defendant, to protect the police against any claim of lost property, and to protect police personnel and others from any dangerous instruments. Douglas, 40 NY 3D at 389. Moreover, the protocol must limit the discretion of the officer in the field, ID. Quotations omitted. The people carry the burden to establish the validity of the protocol itself, specifically, that the procedure meets those three objectives and sufficiently limits the discretion of searching officers, ID. In addition, the people must also demonstrate that these particular officer, S, conducted this search properly and in compliance with established procedures, ID. Quoting Johnson, 1 NY 3D at 256. Importantly, to be a valid inventory search, the people are required to establish that the search actually produced a meaningful inventory list. People v. Gomez, 50 AD 3D 407, 408 dist. Dep 2008, quoting Johnson, 1 NY 3D L 256, noting that the hallmark of an inventory search is a meaningful inventory list. See also Gallic, 80 NY 2D at 720. An inventory search is justified by the fact that a detailed and carefully recorded inventory protects the seized property while it is in police hands and ensures against claims of loss, theft or vandalism, or endorsement. Siak Corbett. Iangraner's backpack at THC Donald's was not a valid search incident to a lawful as, at the suppression hearing, the Altoona police officers claimed that their search of Mr. Mangiane's backpack at the McDonald's was authorized as a valid search incident to a lawful arrest. See, for example, H.R. 595-96, Patrolwoman Wassa testifying that both Sergeant Burns and Patrolman Fox stated that no warrant was necessary because law enforcement could search Mr. Mangiane's backpack at the McDonald's as a search incident to arrest. H.R. 754, Patrolwoman Wassa stating that she had a right to search the backpack under Pennsylvania law as a search incident to a lawful arrest. H.R. 808, Patrolman Fox testifying, every arrest I make is a search incident to arrest whether it is the person or a bag that they have on their person or another person, and that he never sought a search warrant before searching a bag. H.R. 905, Patrolman Fox testifying, I understand where they were coming from, but we did not need a search warrant. It was search incident to arrest. A search warrant was not needed. H.R. 1050, Sergeant Burns stating that law enforcement was authorized to search the backpack because it was a search incident to a lawful arrest. This argument fails under New York law, however, because a search incident to a lawful arrest is limited to items within the defendant's immediate control or grabbable area at the time he was arrested. People v. Thompson, 118 AD, 3D 922, 924, 2D Dep 2014. See also People v. Morales, 126 AD, 3D 43 is Dep 2015. People v. Diaz, 107 AD, 3D 401, 401 is Dep 2013, and People v. Julio, 245 AD, 2D 158, 158 is Dep 1997, all cited above. As is demonstrated from the body-worn camera footage of multiple officers, law enforcement moved Mr. Mangiane's backpack outside of his immediate control approximately 17 minutes before he was arrested. Moreover, at the time of the search, Mr. Mangione was rear-cuffed and separated from his backpack by at least 5 officers, with another 7 officers in the immediate area in the back of the McDonald's. Notably, at least 3 of the officers at the back of the McDonald's, Lieutenant Hanelli, Patrolman Yeager and Patrolman McCoy, were noticeably bigger in size than Mr. Mangione. CHR 996, describing Lieutenant Hanelli as 6'5", 1076, describing Patrolman Yeager as 6 foot, 1,143, describing Patrolman McCoy as 6 foot, that the backpack was not in Mr. Manganeur's immediate control at the time of his arrest was further established by the testimony of Altoona officers at the suppression hearing. For example, Lieutenant Tom Hanelli, the highest-ranking law enforcement member at the McDonald's where Mr. Manganeur was arrested, testified that he did not tell officers to move Mr. Manganeur further away from his backpack at the time of the search because he did not believe it was plausible that Mr. Manganeur could access his backpack while rear-cuffed and surrounded by officers, and Mr. Manganeur was formally arrested and searched ultimately by officers Fry and Detwiller. Correct. Yes, and at the time that he was formally arrested and taken into custody, officers Fry and Detwiller searched Mr. Manganeur, did a more in-depth search of his clothing. Correct. Yeah, they removed his outer layers of clothing to conduct a more thorough scanning, and at that time you did not tell anyone to move the backpack further away from Mr. Manganeur while they were conducting that search. Correct. That is correct. And you didn't tell officers Fry and Detwiller to move Mr. Manganeur away from the backpack and do the search elsewhere, right? Correct. Concern that he could access it, correct. I didn't think that was plausible because he was cuffed and he was rear-cuffed, correct. He had been cooperative up till that point, and he was in handcuffs, correct. He was in handcuffs, yes. T. 10 Millilly, Sergeant John Bums II, his ranking law enforcement vice at the McDonald's, testified that Mr. Manganeur was not in control of his backpack at the time of the arrest and search. At the moment when officers Wasser and Fox were going through the backpack, Mr. Manganeur was not in control of his backpack, was he? That is correct. He wasn't holding it, right? No, in fact, he was handcuffed, so he couldn't reach it, right? Yes, and there are officers between him and the backpack, right? Yes. HR 1088, another officer, Patrolman Samuel McCoy, started searching Mr. Manganeur at the time of his arrest. As with Lieutenant Hanelli and Sergeant Burns, Patrolman McCoy also testified that Mr. Manganeur was separated from his backpack and surrounded by officers at the time of his arrest, A9 Seaton, and at the time when Mr. Manganeur is being searched. It is you, Detwiller and Fry searching him, correct. Yes, and Iris Rocks and Wasser doing the backpack, correct. And these other officers that you mentioned, Hanelli, Christ, Burns, Trent, Avila, Teveral and Tote area, correct. I believe they are still at the McDonald's, yes. AL Tasbolt, a same, Nisria Kuhn Inti, yes. It is our policy that unless it is a female that is actively pregnant, they are to decated pen in Myro Kanu era several officers around near corrector. So you weren't concerned that Mr. Manganeur was going to kick off his sneakers, evade the officers and try to open up the backpack with his feet, were you? No, because we had good body positioning, and you were separating him from his backpack, correct. Correct. HR 1153-54. Given the body-worn camera footage and the law enforcement testimony at the suppression hearing establishing that the backpack was not in Mr. Manganeur's immediate control at the time of his arrest, the district attorney's office cannot meet their burden establishing a valid search incident to a lawful arrest. See People v. Mabry, 37 NY, 3D 933, 934, 2021. The People failed to establish that the warrantless search of defendant's backpack was a valid search incident to arrest. The record does not contain evidence supporting a determination that the backpack was in defendant's immediate control or grabbable area. Internal quotation omitted. See Generally People Volume Jimenez, 22 NY, 3D 717, 721, 2014. Or warrantless searches presumptively are unreasonable per se, and, thus, where a warrant has not been obtained, it is the people who have the burden of overcoming this presumption of unreasonableness. Quotation and alteration omitted. At the hearing, the district attorney's office made several arguments attempting to salvage the improper search at McDonald's. All these arguments fail. First, The prosecution noted with nearly every Altoona law enforcement witness that the witness was only familiar with Pennsylvania law and not New York law. This argument fails for two reasons. First, as noted above, New York law applies to this suppression hearing, not Pennsylvania law. Second, the McDonald's search was not a valid search incident to a lawful arrest even under Pennsylvania law. Specifically, much like New York law, Pennsylvania law limits a search incident to arrest to the person arrested in the area within his immediate control. See, for example, Commonwealth v. Williams, 305A, 3D 89, 97, PA, Super 2023. The search incident to arrest exception allows arresting officers, in order to prevent the arrestee from obtaining a weapon or destroying evidence, to search both the person arrested and the area within his immediate control. Citation and quotation omitted. See also Commonwealth v. Wright, 742A, 2D 661, 665, 1999. A warrantless search incident to an arrest is valid only if it is substantially contemporaneous with the arrest and confined to the immediate vicinity of the arrest. Quoting Shipley v. California, 395 U.S. 818, 819, 1969. While the parameters of a search incident to arrest includes containers and clothing, it is limited to containers and clothing that are in the arrestee's possession at the time of his arrest. Commonwealth v. Williams, 305A, 3D at 97. Because Mr. Mangione did not have possession of his backpack at the time of this arrest, law enforcement's warrantless search cannot be justified as a search incident to a lawful arrest under Pennsylvania law. Notably, the same is true under federal law, where the Supreme Court has limited a search incident to a lawful arrest to the arrestee's person and the area within his immediate control, construing that phrase to mean the area from within which he might gain possession of a weapon or destructible evidence. Chimmel v. California, 395 U.S. 752, 763, 1969. In Chimmel, the Supreme Court set out the following rationale and limitations for searches incident to a lawful arrest. When an arrest is made, it is reasonable for the arresting officer to search the person arrested in order to remove any weapons that the latter might seek to use in order to resist, arrest, or technical escape. Otherwise, the officer's sanity might well be endangered, and the arrest itself frustrated. In addition, it is entirely reasonable for the arresting officer to search or incise any evidence on the arrestee's person in order to prevent its concealment or destruction, and the area into which an arrestee might reach in order to grab a weapon or evidentiary items must, of course, be governed by a like rule. A gun on a table or in a drawer in front of one who is arrested can be as dangerous to the arresting officer as one concealed in the clothing of the person arrested. There is ample justification, therefore, for a search of the arrestee's person and the area within his immediate control, construing that phrase to mean the area from within which he might gain possession of a weapon or destructible evidence. There is no comparable justification, however, for routinely searching any room other than that in when an arrest occurs, for that matter, for searching through all the desk drawers or other closed or concealed areas in that room itself. Such searches, in the absence of well-recognized exceptions, may be made only under the authority of a search warrant. The adherence to judicial processes mandated by Iron Rod Amendment requires no less. Chimmel, 395 U.S. at 762-63, quotations and footnote omitted. See also ID, at 768. The search here went far beyond the petitioner's person and the area from within which he might have obtained either a weapon or something that could have been used as evidence against him. There was no constitutional justification, in the absence of a search warrant, for extending the search beyond that area. The scope of the search was, therefore, unreasonable under the 4th and 14th Amendments, and the petitioner's conviction cannot stand. 40 years later, in Arizona v. Gant, the Supreme Court again explained the Chimmel Court's rationale for limiting searches incident to a lawful arrest to only the arrestee's person and the area within his immediate control. In Chimmel, we held that a search incident to arrest may only include the arrestee's person and the area within his immediate control, construing that "ores" to mean the area from within which he might gain possession of a weapon or destructible evidence. That limitation, which continues to define the boundaries of the exception, ensures that the scope of a search search incident to arrest is commensurate with its purposes of protecting arresting officers and safeguarding any evidence of the offence of arrest that an arrestee might conceal or destroy. Seabird, noting that Karcher's incident to arrest are reasonable in order to remove any weapons the arrestee might seek to us and in order to prevent the concealment or destruction of evidence, emphasis added, if there is no possibility that an arrestee could reach into the area that law enforcement officers seek to search, both justifications for the search incident to arrest exception are absent, and the rule does Arizona versus Gant, 556 U.S. 332, 339, 2009. Quoting and citing Schimmel, see also United States versus Chadwick, 433 U.S. 1, 15, 1977. His search was conducted more than an hour after federal agents had gained exclusive control of the Foot Locker and long after respondents were securely in custody. The search therefore cannot be viewed as incidental to the arrest or as justified by any other exigency. Given the legal limitations for searches incident to a lawful arrest under New York, Pennsylvania and Supreme Court case law, it is clear that there was no legal basis for Altoona law enforcement to search Mr. Mangiane's backpack at the McDonald's. Nevertheless, Altoona law enforcement violated Mr. Mangiane's Fourth Amendment rights by conducting their illegal search. Moreover, as is evident from the hearing testimony, this was not an isolated constitutional violation. Rather, several Altoona law enforcement officers testified at the hearing that they have never sought a search warrant before searching a defendant's bag after an arrest. This is true whether the bag was within the area of the defendant's immediate control or not. For example, Patrolman Fox testified that very arrest is a search incident to arrest whether it is the person or a bag that they have on their person or another person. H.R. 808, Patrolman Fox made clear that he never sought a search warrant when searching a bag and instead searched the bag wherever it was recovered as part of a search incident to a lawful arrest. H.R. 808, see also H.R. 905. Patrolman Fox testifying, I understand where they were coming from, but we did not need a search warrant. It was search incident to arrest. A search warrant was not needed. Similarly, Patrolman Detwiller testified that the rule of the Altoona Police Department with respect to searching a bag or closed container of anybody under arrest is to search everyone that's being arrested, their person and their bags. H.R. 288. Patrolman Detwiller further testified that it was his practice not to get a search warrant when searching bags or backpacks pursuant to a search incident to a lawful arrest. H.R. 290-91. Patrolwoman Wasser similarly testified that she had searched hundreds of bags incident to a lawful arrest in her 19-year career and she had never sought a search warrant before conducting the search. H.R. 630, 755. Even their supervisor, Lieutenant Hanelli, testified that he has searched thousands of bags incident to a lawful arrest and had never once sought a search warrant before conducting the search. H.R. 973. This testimony demonstrates that Altoona law enforcement's conduct in this case was not a mistake or reliant on Pennsylvania law. It was an intentional and egregious violation of Mr. Mangiane's Fourth Amendment rights. Second, the district attorney's office elicited testimony at the hearing that, at the time of the search, Mr. Mangione was between 2 to 3 feet, H.R. 822, or 5 feet, H.R. 751, from the area where the backpack search was being conducted. H.R. 267. Patrolman Detwiller testifying that Mr. Mangione was 2 or 3 feet away from where Patrolwoman Wasser and Patrolman Fox was searching the bag. H.R. 400, 404. Patrolman Fry testifying that Mr. Mangione was approximately 2 feet from the backpack at the time of the search. H.R. 809. Patrolman Fox testifying that Mr. Mangione was about 4 or 5 feet from the backpack at the time he was searching it. In eliciting this testimony, the prosecution is seemingly arguing that the backpack was in Mr. Mangiane's immediate control at the time of the search because of his proximity to the bag. This argument fails because it was Altoona law enforcement that created this situation by moving Mr. Mangione closer to the backpack. As noted at the hearing, Altoona officers chose where to place Mr. Mangiane's backpack. H.R. 214, 327-28. Patrolman Detwiller testifying that he moved the backpack away from Mr. Mangione so that he was in between Mr. Mangione and the backpack. HR 385, 388, 487. Patrolman Fry stating that Patrolman Detwiller moved Mr. Mangone's backpack first, and then Patrolman McCoy moved it to a separate table about 8 or 9 feet away. HR 898. Patrolman Fox claimed that an officer moved the backpack to an adjacent table so that Mr. Mangione couldn't access it. HR 1009. Lieutenant Hanelli testifying that Patrolman McCoy moved the backpack from where Mr. Mangione was seated at the table to 6 feet away. HR 1129, 1147, 48 Officer McCoy stating that he collected the property and put it on a table that was far enough away from Mr. Mangione. Altoona officers then chose where Mr. Mangione was placed when he was arrested, and officers started searching the backpack. HR 363. Patrolman Detwiller testifying that he moved Mr. Mangione so he could search him. HR 506. Patrolman Fry stating that he and Patrolman Detwiller placed Mr. Mangione 2 feet from the backpack while Patrolwoman Wassa searched it. HR 765-66. Patrolwoman Wassa testifying that Patrolman Detwiller and Fry moved Mr. Mangione to the area in between the two tables while she searched the backpack. HR 873. Patrolman Fox acknowledging that officers Fry and Detwiller place Mr. Mangione at the location where he was standing while Fox searched the backpack. R1084. Sergeant Burns stating that Altoona officers decided where to search Mr. Mangione. HR 1153. Patrolman McCoy confirming that Patrolman Detwiller moved Mr. Mangione to the position where they started searching him. Therefore, because the police themselves cannot by their own conduct create an appearance of exigency, People v. Leban, 62 NY, 2D 139, 146, 1984. The fact that law enforcement moved Mr. Mangione closer to the backpack does not render this an exigent circumstance allowing officers to search Mr. Mangone's backpack. Furthermore, as described above, Lieutenant Hanelli, Sergeant Burns and Patrolman McCoy all testified that Mr. Mangione could not access his backpack at the time of the search because Mr. Mangione was rear-cuffed and there were officers surrounding Mr. Mangione and blocking him from the backpack. See also HR 874. Patrolman Fox testifying that, while law enforcement could have moved the backpack and searched it elsewhere, there was no need to because officers had the area controlled. Mr. Mangione was in handcuffs and had been cooperative the whole time. Accordingly, the fact that Mr. Mangione was between 2 to 5 backpack at the time of the search does not render the backpack within his immediate control, or enforcement's search of Mr. Mangone's backpack at the McDonald's was not justified as a search for a bomb. The district attorney's office next claims that, even if the backpack search at McDonald's was not justified as a search incident to a lawful arrest, the search was still proper because officers were searching to make sure there was no bomb in the backpack. Contrary to the prosecution's argument, the totality of the circumstances demonstrates that the officer's claim about a bomb was a blatantly false and pretextual justification for conducting an evidentiary search. First, nothing about the alleged shooting in New York 5 days earlier or law enforcement's interactions with Mr. Mangione and the McDonald's that day provided a reasonable basis to believe that there was a bomb in the backpack. 2 degrees to the contrary, as noted on pages 22-23 above. The hearing testimony established that Mr. Mangione was fully compliant with law enforcement's requests at the McDonald's. Instead, the officers searched the backpack for a bomb because that is something they always do so as not to pull a Moser and bring a bomb back to the station. HR 588-89. See also HR 892. Patrolman Fox, like I said, the bomb threat is always there in the back of my head no matter what bag I am searching. Under New York law, however, exigency is not demonstrated unless it is supported by circumstances giving rise to an objectively reasonable suspicion. See, for example, People v. Diaz, 107 AD, 3D 401, 402 Step 2013. See also Welsh v. 20. Patrolman Fox testified at the hearing that he was suspicious that there might be something dangerous in the backpack because, when he had asked Mr. Mangione if there was anything in the bag that he needed to know about, Mr. Mangione responded that he was going to remain silent, HR 804-875. However, by the time Patrolman Fox had this conversation with Mr. Mangione, Patrolwoman Wasser already had her gloves on and was about to open the backpack to begin searching, demonstrating that she was set to search the backpack even before Fox approached Mangione to ask him that question, and that Mangone's response was not the basis for her decision to search the backpack. Wisconsin, 466 U.S. 740, 74950, 1984, police bear a heavy burden when attempting to demonstrate an urgent need that might justify warrantless searches or arrests. Here, there was no exigency as officers had no specific justifiable reason to believe Mr. Mangione had a bomb in his backpack. Law enforcement simply used the excuse of a potential bomb to justify a warrantless search. Second, if law enforcement was legitimately concerned about a bomb, they would have cleared the McDonald's and not allowed customers and employees to walk through the area where a bomb might be located. Law enforcement also had the option of moving the backpack to the parking lot, farther away from many civilians. However, instead of taking the situation seriously, which would be consistent with a legitimate concern of a bomb, officers instead laughed and joked about how they would rather have the bomb there than at the precinct, with Patrolman Fox further joking that a jow can blow me up, but you don't want to blow blue. Fox's canine officer. HR 592-812. Third, and most notably, the body-worn camera footage establishes that this was a search for evidence, not a search for a bomb or a dangerous instrument such as a gun. For example, one of the first items that Patrolwoman Wasser took out of the backpack was a bag too small to carry a bomb or a gun. As Patrolwoman Wasser acknowledged at the suppression hearing, she did not believe that there could be a bomb inside that small bag. HR 679. Nevertheless, Patrolwoman Wasser opened the bag and removed the phone and passport that were inside, rather than returning the passport or the bag and continuing her search, as one would expect if this were a search for a bomb. Patrolwoman Wasser instead gave the passport to other officers at the Mcdonald's to assist in the Altoona's false statement/forgery investigation and the NYPD's New York City shooting investigation. Patrolwoman Wasser then removed an envelope, also too small to contain a bomb or a gun, which she examined before returning it to the backpack. Patrolwoman Wasser also searched through a wallet that she removed from the backpack, another item that was obviously not a como, a gun or a dangerous instrument. Additionally, during the search, Patrolman Fox used a knife to slice open a small cardboard container too small to contain a bomb, a fact that Patrolman Fox admitted during the hearing. Did you think there was a bomb wrapped up in the cardstock that you opened with the knife? No, I could tell it was some type of data chip. I just wasn't sure. HR 893. Despite knowing that this container did not contain a bomb, Patrolman Fox nevertheless opened the container hoping to recover evidence to support the NYPD investigation into the New York City shooting. That this bomb search was pretextual is further demonstrated by the fact that, once Patrolwoman Wasser found the loaded gun magazine in the backpack, Patrolman Fox stated to Wasser, "Now that we found that is, the magazine, let's just take it back to the precinct." X6E, 1 at 10 hours, 1 minute, and 48 seconds. If this truly were a search for a bomb, officers would have continued searching the backpack before taking it to the precinct, especially considering that Patrolwoman Wasser and Patrolman Fox had searched only a portion of the backpack before finding the magazine, and never to Patrolman Fox's admission that he searched the cardboard container despite knowing it was not a bomb is not sure, or is he, given his earlier testimony that the main reason he was seeking out the backpack was because he was conducting a search incident to lawful arrest. CHR 892. Like I salu, ein bomber cat is always innering tne back or my need no matter what baglam searching. I am skulking his bag incident to arrest. The threat of a bomb is also there, or threat of any device. Einol can harm numen ein. Out that's not any sole reason I am searching that bag. Jam searching that bag incident to arrest. As established above, there was no legitimate basis to skulk the backpack medino or a war arrest. And searched a third compartment in the backpack for a bomb. Furthermore, the fact that law enforcement had found a loaded magazine in the backpack would have given officers more reason to suspect that there might be a bomb or something dangerous in the backpack. Yet, because this was an evidence search and not a search for a bomb, Altoona officers immediately stopped searching at the McDonald's once they found incriminating evidence and took the backpack to the precinct. At the hearing, Patrolwoman Wasser and Patrolman Fox indicated that they also searched the backpack at the McDonald's because the gun used in the New York City shooting was never found. HR 577, 777, 782, 875. Notably, while at the McDonald's, the only stated concern Patrolwoman Wasser and Patrolman Fox gave for searching the backpack at the McDonald's and not at the precinct was because they were making sure there was no bomb. Neither Patrolwoman Wasser nor Patrolman Fox stated any concern at the time that there might be a gun in the backpack because the gun from the New York shooting was never recovered. Instead, this was a post hoc excuse that law enforcement advanced at the suppression hearing to attempt to now justify the warrantless search of the backpack, to the extent Patrolwoman Wasser and Patrolman Fox testified that they stopped searching because they were confident based on their limited search that there was no bomb in the bag. HR 592, 599 600, 697 98, 752. Patrolwoman Wasser stated that at the point she found the magazine, she was satisfied that there was no bomb because she had searched the biggest part of the bag. HR 878. Patrolman Fox testified that he was satisfied that he did not see any device that appeared to be an explosive device. This testimony defies logic. As noted earlier, Patrolwoman Wasser did not finish searching the backpack compartment that she had started searching where the silencer was ultimately recovered. Similarly, Patrolman Fox did not finish the compartment that he had started searching because he spent the majority of his time opening the small cardboard that housed a computer chip. HR 878. Moreover, neither of them searched the backpack's third compartment at the McDonald's, the compartment where Patrolwoman Wasser found the gun at the precinct. Likewise, Patrolman Fox's claim at the hearing that he was concerned that there might be something dangerous in the backpack because Mr. Mangione had a knife on him at the McDonald's, HR 805, also cannot survive scrutiny. As this court saw at the hearing, the knife that Patrolman Fox was referring to was a pocket knife with a 3/4-inch blade that was not illegal for Mr. Mangione to carry. X8A 305, HR 499, 866-67. Moreover, Mr. Mangione informed Patrolman Fox that he had the pocket knife on him after both Patrolman Agnifilo and Fox had already frisked the pocket where the knife was located, and he never reached for the pocket knife while at the McDonald's. X6B, 1 at 9 hours, 50 minutes, and 5 seconds 9 hours, 50 minutes, and 18 seconds, HR 521, 920, 1155. Given the small size of the pocket knife, the manner it was recovered, by Mr. Mangione volunteering it to law enforcement, and the fact that Mangione never reached for it, there is no reason to believe that Patrolman Fox considered the fact that Mangione had the knife on him as a reason to search the backpack. This is particularly true given that, while at the McDonald's, Patrolman Fox never mentioned the knife as a basis for the search and instead first mentioned it at the suppression hearing. Furthermore, it is evident that the knife did not create security concerns that there was a dangerous instrument in the backpack as Patrolman Agnifilo moved Mr. Mangione closer to the backpack after Mangione told them about the knife. HR 537. The court should therefore not credit these post hoc excuses to search the backpack at the McDonald's for Patrolwoman Wasser's searches at the precinct were not valid inventory searches. Altoona law enforcement conducted several warrantless searches of Mr. Mangione and his backpack at the precinct. 1. Patrolman Friesen Homan's search of Mr. Mangione's person in the intake area. 2. Patrolwoman Wasser's search of Mr. Mangione's backpack on a folding chair in the intake area. 3. Patrolwoman Wasser's search of Mr. Mangione's backpack in the hallway outside the intake area, and 4. Multiple officers' search of Mr. Mangione's backpack in Patrolman Agnifilio's office and then in the roll call room, while the first and last searches appear to have the hallmarks of an inventory search. The two searches conducted by Patrolwoman Wasser at the precinct, referred to in the paragraph above as searches, 2, and 3 were warrantless evidence searches and not inventory searches. The scark on the metal folding chair, as depicted in her body-worn camera footage and her hearing testimony, patrolwoman Wasser entered the intake area and placed Mr. Manganeur's backpack on a metal chair in the corner of the intake area. She started her search by briefly unzipping then quickly rezipping the middle compartment of the backpack, which she had already searched at the McDonald's, but stopped looking through once she found the loaded magazine. Patrolwoman Wasser immediately closed the middle compartment and unzipped the front compartment, which she claimed to have not searched before. Instantaneously, Patrolwoman Wasser found a loaded firearm clearly visible in the front compartment. Patrolwoman Wasser's body-worn camera footage makes clear that this was not an inventory search, but that she knew exactly what she was looking for and where to look for it. After mistakenly opening the middle compartment, Patrolwoman Wasser immediately closed the compartment because she knew that what she was looking for was not in the middle compartment. Had this been an inventory search, she would have had no reason not to start inventorying the items from the middle compartment, especially since she had not finished searching through this compartment at the McDonald's. Rather, Patrolwoman Wasser immediately closed this middle compartment because she was not looking to inventory the contents of the backpack, but was looking for something specific, the firearm. This is also evident from the fact that Patrolwoman Wasser conducted this search on a folding chair in the corner of the intake section, where there was not even a table to place the items on. By this point, Patrolwoman Wasser had already known from her preliminary search at the McDonald's that the backpack was filled with a large amount of Mr. Manganeur's personal property. As Patrolwoman Wasser testified at the hearing, she knew there were a lot of items in that backpack, including multiple small items, large items, clothing and computer chips because she had seen them at the McDonald's. HR 720/21. Patrolwoman Wasser also acknowledged that an inventory search is a very methodical search, with the purpose to catalogue every item. HR 733. It would not be possible to remove these items and inventory them in the limited space in the corner of the intake area, yet that is the exact area where she chose to start her supposed inventory search. Tellingly, she also started this search without paper to make an inventory list, and without evidence bags or tags. HR 720. Moreover, after hastily closing the middle compartment of the backpack, Patrolwoman Wasser immediately opened the front compartment where the firearm was conveniently located right on top. The only conceivable reason for this sequence was because she already knew where the firearm was located because she had already looked through that compartment of the backpack on her way to the precinct. Not only would this explain why the trip to the precinct took inexplicably longer than it should have, this would also explain why Patrolwoman Wasser kept the disposable gloves on her hands while driving to the precinct, something she testified she did not normally do. HR 725. At the McDonald's, Patrolwoman Wasser put the gloves on her hands. In fact, the backpack carried so many items that the subsequent search of the backpack was first moved to a small office area before being moved to Patrolman Featherstone's office because the previous area was not going to be sufficient for them to organize and seize and search the backpack. HR 1285. About to begin searching the backpack so as not to contaminate the evidence. HR 584, 598, 670/71. Once she stopped searching the backpack at the McDonald's, there was no reason for her to keep the gloves on for the ride to the precinct, unless she was going to search the backpack on the way when her body-worn camera was off. Additionally, Patrolwoman Wasser had the time and opportunity on her drive from McDonald's to search the backpack when she stopped on the side of the road to get the McDonald's bag from Patrolman Fox. While her interaction with Patrolman Fox lasted between 10-12 seconds, as per Patrolman Fox, HR 829, or between about 30-40 seconds, as per Patrolwoman Wasser, HR 713. Her drive from the McDonald's to the precinct took nearly 11 minutes, 2 more minutes than it took Patrolman Agnifilo and Fox to drive from the McDonald's to the precinct. This discrepancy in travel time is even more significant given that Patrolman Agnifilo and Fry were stopped at a red light for nearly 1 minute and 41 seconds on their drive. X6A, 3 at 10 hours, 2 minutes, and 55 seconds, 10 hours, 4 minutes, and 36 seconds. We submit the only plausible conclusion is that the extra time it took Patrolwoman Wasser to reach the precinct was because she was searching through the backpack while wearing her disposable gloves on the way to the precinct. That is why she knew exactly where to find the gun as soon as she walked into the precinct. Another fact that supports the finding that patrolwoman Wasa knew exactly where the firearm was located when she started searching in the precinct is that she turned on her body-worn camera the moment she arrived in the precinct's parking lot. She did this because she knew, based on her experience, that the camera would start capturing audio a minute after it was turned on. 2. As patrolwoman Wasa well knew from her 19 years of experience with the Altoona Police Department, there were additional gloves available at the precinct that she could use before starting to search the backpack at the precinct, as her body-worn camera shows boxes of disposable gloves above the front desk of the precinct's intake section. X6F 2 at 10 hours, 15 minutes, and 58 seconds would be the precise moment she would be finding the gun in the backpack in the intake area. While the prosecution may argue that she turned on her body-worn camera in the parking lot because she knew she would be searching the backpack at the precinct and wanted to record her search, it is notable that she did not turn on her body-worn camera at the McDonald's until after she started searching the backpack, even though she had been at the McDonald's for more than 13 minutes before starting the search and knew she would be interacting with members of the public. HR 653, 658. Moreover, patrolwoman Wasa did not turn her body-worn camera on when she received the brown McDonald's bag from patrolman Fox on the side of the road. HR 717. These actions demonstrate that patrolwoman Wasa did not care whether the entire search or chain of custody of the evidence was recorded. Instead, she purposefully turned her camera on when she arrived in the precinct parking lot because she wanted to ensure that the exact moment she recovered the firearm was recorded with full audio on her body-worn camera so that she would get recognition in this high-profile arrest. For all these reasons, patrolwoman Wasa's search on the metal chair in the intake section of the precinct was not an inventory search. Accordingly, the firearm that was recovered during an warrantless search must be suppressed in hallway search after locating a firearm during her evidence search of Mr. Mangione's backpack. Patrolwoman Wasa moved the backpack and the brown McDonald's bag to a hallway outside of patrolwoman Wasa's conduct at McDonald's demonstrated that she was very cognizant of rat video the body-worn camera would capture. Specifically, in one interaction with patrolman Detwiller at the McDonald's, patrolwoman Wasa was about to make a joke or personal comment to patrolman Detwiller before looking directly at his body-worn camera. Realizing the camera was recording, patrolwoman Wasa smiled and chose not to comment. X6A 2 at 9 hours, 55 minutes, and 58 seconds, HR 66869, area of the precinct at Deputy Chief Swope's direction, 2 in what she repeatedly referred to as an inventory search, HR 613, 61718, 632, 63536, 639, 726, 764. Patrolwoman Wasa subsequently removed the property from the backpack and separated the contents between items of evidence for the New York investigation that were placed in evidence envelopes and items that were personal property that were placed back into the backpack. HR 617, 62526, 640, 72930, 74041, 757, 76061. At no time did patrolwoman Wasa make a list of items that were in the backpack originally or the items that we placed back into the backpack after the search. There are several reasons why this search was not a valid inventory search. Most importantly, patrolwoman Wasa was searching for evidence and not taking inventory. As depicted in her body-worn camera footage, she was rummaging through the backpack looking for evidence and then separating evidentiary items for the New York case. For example, silencer, the red journal, cell phone, a camera, from the other items. Additionally, she began this search looking for Mr. Mangione's identification and could not recall where she had placed it, causing her to rummage around several compartments until she located it in the McDonald's bag. Moreover, once she was done searching, she just put the non-evidentiary items back into the backpack without listing what she had taken out. As patrolwoman Wasa acknowledged at the hearing, and percent agrees at the hearing, the district attorney's office elicited from patrolwoman Wasa that Deputy Chief Swope never told her to secure a search warrant after she recovered the firearm. HR 755-56. It is unclear what the significance of this testimony is. As established above, Altoona law enforcement roundly violates search and seizure law and the Fourth Amendment by search and ags incident to a lawful arrest, even if the bag is not within the defendant's immediate control or rabbable area. INL Deputy Chetswag would also violate search and seizure law and the Fourth Amendment by failing to properly advise patrolwoman Wasa to get warrant is not surprising. Furthermore, as established by Altoona Police Department Deputy Chief Nathan Snyder at Th Laurel hearing conducted on January 23, 2026. The Altoona procedure for inventory search would require officers to seek a warrant if a firearm was recovered during an inventory search. A. The 23rd of January 2026 hours 61:62, 65. The transcript to January 23, 2026. Hearing in federal court is exhibited to this submission and will be provided to the court under separate cover. Inventory search is a very methodical search, with the purpose to catalogue every item. HR 733. Here, patrolwoman Wasa's search was not methodical, and she did not even bother to catalogue or label any of the items, a fact that is further supported by patrolman Featherstone's testimony that everything was labelled, yet when all the items were transferred to his office after the hallway search. HR 1286. Furthermore, Sergeant Burns asked patrolwoman Wasa during this search to photograph the barcode from the sandwich and bread that were in the backpack so law enforcement could try to determine which local store these products were purchased from. X6F, 2 at 10 hours, 20 minutes, and 20 seconds, HR 731, that is consistent with searching for evidence, not inventorying. As the New York Court of Appeals has ruled, however, highly incriminating evidence may be a consequence of an inventory search, it should not be its purpose. People v. Johnson, 1 NY, 3D 252, 256, 2003. Here, considering all the evidence, patrolwoman Wasa's conduct on the body-worn camera demonstrates that the true purpose of the search in the hallway was to look for incriminating evidence and not inventory the backpack. See, for example, Johnson, 1 NY, 3D at 257, crediting that hearing court's conclusion that the claim that the search was an inventory search was less than a believable claim, and it appears to be merely a pretext to cover for what was the officer's desire in the first place. To see what the defendant was up to and to somehow get into the interior of his car to see if the defendant was in possession of contraband or the weapon. Consequently, this search was not a valid inventory search and the items recovered must be suppressed. 27. The Johnson court's concern that the claim of an inventory search was pretextual is greater in this case because Sergeant Burns testified that patrolwoman Wasa's search in the hallway was merely to remove contraband or suspected weapons and items like that. HR 1098. When counsel followed up with the question, so this wasn't an inventory search, was it? Sergeant Burns responded that it would be both. HR 1098. Similarly, Sergeant Houston referred to the hallway search as a search incident to a lawful arrest and an inventory search happening simultaneously. 1. In response, the district attorney's office will attempt to argue that patrolwoman Wasa's hallway search should be viewed as a continuous inventory search that culminated in the inventory search that officers completed in patrolman Featherstone's office and then in the roll call room. This argument belies the record, as nothing was labeled or inventoried in the hallway search. All patrolwoman Wasa did was search the bag for evidence. Once that search was completed and evidentiary items were separated, only then were all the contents of the backpack given to patrolman Featherstone, the precinct's evidence custodian who maintained chain of custody. HR 1269-10 be photographed and inventoried. HR 74142, 746. At the point that patrolman Featherstone received the backpack, its contents had not been itemized, photographed or labeled. HR 742. This is in sharp contrast to the search of Mr. Mangione's person that patrolman Fry and Homan conducted in the intake area. In that search, patrolman Fry methodically went through each piece of Mr. Mangione's clothing before putting all the items in bags. X6B, 4 at 10 hours, 32 minutes, and 6 seconds. As noted by Sergeant Houston, when you're doing the intake process, an officer is generally writing down what is being put in the bag, so part of his training and experience, he's naming each item as he drops it in the bag. HR 1190. In this process, Patrolmen Fry and Herman were addressing all property equally and were not separating items based on what they believed the item's evidentiary value might be. In that scenario, one could possibly argue that the inventory search started in the intake area and was later completed by Patrolman Featherstone. With the hallway search, however, no inventory was even started. Patrolwoman Wasser was just searching. HR 1253. See also HR 1170. Sergeant Houston referring to the intake searches as a search incident to a lawful arrest, and it's also an inventory search of the property where basically you're doing two things simultaneously. It is evident here that Patrolwoman Wasser's inventory claim was pretextual, as she was focused on finding evidence for the New York investigation and never created an inventory. The backpack for evidence to be shared with the NYPD, with whom Altoona law enforcement were in almost constant contact. Once she found the evidence, Patrolwoman Wasser indiscriminately jammed all the other items back into the backpack. Under these circumstances, the prosecution cannot credibly argue that Patrolwoman Wasser was conducting an inventory search that was completed later. The search in Patrolman Featherstone's office. Once the evidentiary search in the hallway was completed, officers moved all the items from the backpack to another office to complete an inventory. This search was subsequently moved to Patrolman Featherstone's office, before being moved again to the roll call room. During this search, all items recovered from Mr. Mangione and his backpack were photographed, inventoried and placed in labeled evidence bags. While Mr. Mangione's property was inventoried in this process, the search exceeded the procedures authorized by the Altoona Patrol Guide for two reasons. First, the inventory search provision of the Altoona Patrol Guide only reference inventorying property that was removed from the detainee's person, not from bags or containers that were not on the detainee's person. Specifically, at the hearing, the prosecution argued that General Orders 3.1.9 and the 3rd of January 2010 of the Altoona Patrol Guide, admitted as Exhibit 10B at the hearing, authorized Altoona officers to inventory all of Mr. Mangione's property. A simple reading of 3.1.9, however, demonstrates that this general order refers only to searches of the detainee's person. Tellingly, 3.1.9a is titled Inventory Search of the Detainee. Moreover, 3.1.9a.1 states that all detainees placed in the cell block area shall be thoroughly searched by the processing officer, regardless of any prior searches that occurred in the field. The next provision, 3.1.9a.2, expands on the previous provision by stating, whenever possible, a search of the detainee shall be conducted by an officer or other member of the same sex as the detainee, and that this search should be conducted in a safe and discreet manner. These two provisions, read together, indicate that the search being conducted is a search of the detainee's person where the searcher would be physically touching the detainee. That is why it is important that the search be conducted by a member of the same sex, and that the search be conducted in a safe and discreet manner. If these provisions referred to the search of the detainee's bag or backpack, there would be no reason to have the search be completed by a member of the same sex, or in a safe and discreet manner, as there is no need to physically touch the detainee to search their bag or backpack. The next provision, 3.1.9a.3, also contemplates a search of the detainee's person, as it directs that special attention be given to search those areas where items could be hidden, and refers specifically to clothing or parts of clothing that the detainee was wearing, i.e. jacket linings, hidden pockets, hats, belts, footwear, clothing seams, pant waists, and/or cuffs. The same is true for 3.1.9a.5, which references strip searches and body cavity searches. Accordingly, all the provisions of 3.1.9 pertain only to searches of the detainee's person and not a detainee's property that was not on his person. Sergeant Burns acknowledged this at the hearing by noting that 3.1.9 authorizes only the inventory search of the detainee and the property that was on the detainee's person. HR 1103, 1104, 28, the District Attorney and Altoona Police Department next attempt to rely on General Order the 3rd of January 2010 for authorization to conduct an inventory search of the detainee's property that was not on the detainee's person. HR 1107, Sergeant Burns stating that the 3rd of January 2010 authorizes a search of the detainee and any property he had with him at the time of being detained or arrested. This argument has no support in the language of the 1st of March 2010. As an initial matter, the 3rd of January 2010 is titled Secure 28. The 3.1.9 only refers to the search of a detainee's person was further confirmed by the testimony of Altoona Police Department Deputy Chief Nathan Snyder at January 23, 2026, hearing in federal court addressing the scope of the Altoona General Orders, X, A, 1, 2, 3, 26 hours 32:39. Storage of detainee's property and refers only to storage of a detainee's property. It does not itself authorize inventory searches. Furthermore, when read together with 3.1.9, these two provisions establish a procedure for officers to conduct an inventory search of the detainee's person, described in 3.1.9, and then instruct officers how to store the items that were recovered in that search of the detainee's person, described in the 1st of March 2010. The connection between the two provisions is also established by the fact that both provisions reference property removed from the detainee. See 3.1.9, A, 6, establishing that LL property removed from the detainee shall be itemized utilizing a prisoner property form, and the 3rd of January 2010, A, 2, establishing that C, contraband, evidence and or illegal weapons removed from the detainee shall be placed into evidence as required by agency policy and not returned to the detainee. Emphasis added. These two provisions use the same language because they describe the same type of property. Because we have already established that 3.1.9 refers only to property on the detainee's person, the 3rd of January 2010 must be read to address the same type of property. Accordingly, like with 3.1.9 earlier, the 1st of March 2010 also fails to authorize Altoona officers to conduct an inventory search of a detainee's property that was not recovered from the detainee's person. Consequently, to the extent Patrolman Featherstone's inventory 29 Sergeant Burns testified that, while 3.1.9 did not authorize a search of a detainee's property not recovered from his person, such a search was authorized by General Order 1.2, admitted as Exhibit 10A, HR 1104, as established at the hearing. General Order 1.2 only addressed inventory searches in the context of impound searches of cars. HR 1106, it did not provide any other authorization of inventory searches. Moreover, if Altoona law enforcement was relying on the automobile search provisions in General Order 1.2 for authorization to conduct an inventory of Mr. Mangione's backpack, those provisions clearly study under 1.2.5 that, if evidence of a crime is discovered during an inventory search, the officer shall stop the inventory search and secure a search warrant prior to continuing. X10A at page 8. Needless to say, the officers here did not comply with the directives in General Order 1.2.5 to secure a search warrant after discovering evidence of a crime. Search also covered items recovered from Mr. Mangione's backpack. Such an inventory search was not authorized by Altoona's General Orders. Second, even assuming the Altoona General Orders authorized an inventory search of Mr. Mangione's backpack, it did not. The search conducted in this case exceeded that authorization. Most notably, as part of this search, officers opened, photographed and read Mr. Mangione's journal and other writings. For example, Sergeant Burns testified that he read some of the journal just out of curiosity, saw pages labeled blog and others with miscellaneous writings, and photographed pages that he thought were relevant to the New York investigation. HR 1101-03. Similarly, Sergeant Houston admitted that he read some of the writings, including the journal, and photographed the pages of the journal that he thought might be pertinent to the New York investigation. HR 1234-35. Reading these writings exceeded the inventory procedures allowed under the Altoona Patrol Guide, as General Order the 3rd of January 2010, of the Patrol Guide authorized officers to complete a documented itemized inventory of all items taken from the detainee. X10B, Altoona Police Department General Order 3.1. Even assuming this provision applied to Mr. Mangione's backpack, it would only authorize officers to remove the journal from the backpack and note that a journal was recovered. It would not allow officers to read through the Journal 30. Furthermore, reading Mr. Mangiane's writings violated New York law. A similar issue was addressed in People v. Somerville, 170 Miscellaneous 2D 1024, 1025, SCT, Kings CTY 1996, where an officer opened the defendant's backpack after an arrest and itemized all items, including the defendant's calendar book, after opening the calendar book and making sure there was nothing between the pages. The officer read through entries that the officer thought might be significant. Deputy Chief Nathan Snyder confirmed during the federal hearing that the Altoona General Orders does not allow officers to read a Delaney's writings during an inventory search. X.A. the 23rd of January 2026 hours 51. His investigation, ID. In addressing the police inventory procedures, the court noted that it must meet two standards of reasonableness. First, the procedure must be rationally designed to meet the objectives that justify the search. Second, the procedure must limit the discretion of the officer in the field. ID. Citing Florida v. Wells, 495 U.S. 1, 4, 1990, the court further noted that the relationship between the search procedure adopted and the governmental objectives that justify the intrusion, as well as the adequacy of the controls on the officer's discretion, must then be examined. Somerville, 170 Miscellaneous 2D at 1027, citing People v. Gallick, 80 NY, 2D 715, 719, 1993. At the suppression hearing in Somerville, the officer testified that the routine procedure for conducting an inventory search of a book was shaking the book upside down, feathering its pages, and then looking at each page. Somerville, 170 Miscellaneous 2D at 1027. The court recognized that the looking aspect of the procedure may be related to one or more of the three underlying purposes that justify an inventory search, as it may protect an owner's property while in the custody of the police if small valuables are secreted within the pages, and may in certain instances guard the police from dangerous instrumentalities such as razors or thin blades that may otherwise go undetected. ID. The court then distinguished between simply looking at a page as opposed to reading the actual entries on the page, the latter of which involved the officer's affirmative and considered decision to discern the contents contained therein. ID. The court found that the inventory process should not permit an officer at his unbridled discretion to elect to read entries that might prove relevant to his investigation, because such discretion runs afoul of the second standard of reasonableness. ID. The court further found that a police officer is not allowed to search for the sole purpose of investigation, even when he is following standardized care routines as a part of the inventory process. The individual police officers must not be allowed so much latitude that inventory searches are turned into a purposeful and general means of discovering evidence of a crime. ID. Quoting Florida v. Wells, 495 U.S. at 4, in suppressing the calendar book, the court concluded, while a police officer's leafing through the individual pages in a weekly appointment calendar book may further one or more of the governmental interests sought to be protected in the context of an inventory search, the reading of the entries therein there's no such purpose. Somerville, 170 Miscellaneous 2D at 1028. A similar analysis was conducted in United States v. Santos, 961 F sub 71, SDNY 1997, where the court ruled that conducting an inventory search did not allow the inventorying officer to read the written materials found among the defendant's personal property. In doing so, the court noted that the underlying justifications of the inventory search exception make clear that the objective of caretaking, not investigation, must guide the inventory process. ID. At 74, the court further found that, there is no reason why government officials must read written material in order to inventory an arrestee's personal belongings. The Fourth Amendment requires that they must obtain a warrant before doing so. ID. This court should reach the same conclusion here, by reading Mr. Mangiane's journal entries and other writings. Sergeant Burns and Sergeant Houston exceeded the parameters of a permissible inventory search and instead used the inventory process as a pretext to search for evidence that they believed would be helpful to the New York investigation. Such a search violated the Fourth Amendment, and, accordingly, the contents of the journal and all the rest of Mr. Mangiane's writings that were read in the inventory process must be suppressed. In addition to Mr. Mangiane's journal and the loose papers and notes contained in his backpack, Law enforcement also read a handwritten note that patrolmen Fry and Herman recovered when searching Mr. Mangiane's person at the McDonald's. This writing Exhibit 8B, 15, was a to-do list that Sergeant Houston had after the inventory search of Mr. Mangiane's person in the intake area. Lastly, even assuming Patrolman Featherstone conducted a valid inventory search, the evidence recovered from the backpack must still be suppressed. As noted above, law enforcement's warrantless searches at the McDonald's, on the metal chair and in the hallway were improper. In those searches, all the contents of the backpack were improperly recovered: the gun magazine, the red journal and Mr. Mangiane's passport and cell phone were recovered at McDonald's. The firearm was recovered during the search on the metal chair, and all the remaining contents of the backpack were recovered in the hallway search. Consequently, the district attorney's office has no basis to claim that the improperly recovered evidence should nevertheless not be suppressed, because the evidence would have been inevitably discovered when Patrolman Featherstone conducted an inventory search of the backpack at the precinct. This is because, in New York, the Court of Appeals has established that the doctrine of inevitable discovery does not apply where, as here, the evidence sought to be suppressed is the very evidence obtained in the illegal search, because, permitting its admission in evidence affects what amounts to an after-the-fact purging of the initial wrongful conduct, and it can never be claimed that a lapse of time or the occurrence of intervening events has attenuated the connection between the evidence ultimately acquired and the initial misconduct. The illegal conduct and seizure or the evidence are one and the same. People versus Slith, 69 NY, 2D 313, 318, 1987. The Court of Appeals further noted that admitting illegally obtained evidence through the inevitable discovery rule, what would amount to a post hoc rationalization of the initial wrong, would be an unacceptable dilution of the exclusionary rule, and would defeat the primary purpose of that rule, deterrence of police misconduct, ID, at 319. Additionally, failing to exclude wrongfully obtained primary evidence would encourage, and that he later discussed with NYPD Sergeant Venius at 10:34 a.m., X6B, for at 10 hours, 34 minutes, and 4 seconds to 10 hours, 34 minutes, and 25 seconds. This list must also be suppressed because Sergeant Houston improperly read the contents of the written without a search warrant, or false searches in the hope that probable cause would be developed after the fact. ID. Quoting the Oregon Court of Appeals in State v. Crossan, 21 or App 835, 838, 1975. Because the doctrine of inevitable discovery is inapplicable to primary evidence, that is, the very evidence obtained in the illegal search, there is no basis to admit any of the illegally seized evidence from Mr. Mangiane's backpack. 32C. CG. People v. Stitch, 69 NY, 2D at 318. People v. Julio, 245 AD, 2D 158, 159 or Step 1997. The People's Alternative Argument, that evidence of the gun should be admitted under the inventory exception, ignores the fact that the exception is only applicable to secondary evidence. It is inapplicable in the circumstances at bar where the evidence of the gun is primary evidence, that is, the very evidence obtained in the illegal search. The likelihood that the gun would have been discovered during an inventory search at the police station, therefore, does not vitiate an illegal search and seizure. Since the search of the bag was unlawful, the evidence of the gun must be suppressed. Citation omitted. Mr. Mangiane's statements to law enforcement must be suppressed. 1. Legal standard. Under New York law, a defendant's statements obtained through custodial interrogation without Miranda warnings should be suppressed. See, for example, People v. Corey, 209 AD, 3D 1306, 1307, 4th Dep 2022, vacating the defendant's plea, where the trial court failed to suppress the portions of the defendant's statements made without prior Miranda warnings while in custody and in response to police questioning. People v. Dorval, 175 AD, 3D 708, 710, 2D Dep 2019. Under these circumstances, the defendant was improperly subjected to custodial interrogation without being advised of his Miranda rights, requiring suppression of those statements. People v. 32. This is true whether the district attorney's office attempts to cure the improper search based on inevitable discovery through an inventory search or inevitable discovery through a later search while or 163 AD, 3D 986, 987, 2D Dep 2018, noting that the hearing court erred by not suppressing the defendant's pre-Miranda statements that were the product of custodial interrogation. People v. Davis, 106 AD, 3D 144, 152, 1 Dep 2013, when, as part of a continuous chain of events, a defendant is subjected to custodial interrogation without Miranda warnings, any statements made in response, as well as any additional statements made after the warnings are administered and questioning resumes, must be suppressed. Quotation omitted. In assessing the admissibility of Miranda-less statements, courts must determine 1. Whether the police questioning constituted interrogation, and 2. Whether the defendant was in custody. See, for example, People v. Cabrera, 41 NY, 3D 35, 52, 2023. Miranda warnings must be administered when an interrogation occurs after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Quoting Miranda v. Arizona, 384 U.S. 436, 445, 1966. For Miranda purposes, interrogation refers to any questioning or actions by law enforcement officers that are reasonably likely to elicit an incriminating response from a suspect. People v. Pullman, 5 NY, 3D 122, 129, 2005. The term interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response. The Supreme Court has defined that phrase incriminating response to refer to any response, whether inculpatory or exculpatory, that the prosecution may seek to introduce at trial. Rhode Island v. Innes, 446 U.S. 291, 302 N. 5, 1980. Relying on its Miranda decision, the Supreme Court further noted, no distinction can be drawn between statements which are direct confessions and statements which amount to admissions of part or all of an offense. The privilege against self-incrimination protects the individual from being compelled to incriminate himself in any manner. It does not distinguish degrees of incrimination. Similarly, for precisely the same reason, no distinction may be drawn between inculpatory statements and statements alleged to be merely exculpatory. If a statement made were in fact truly exculpatory, it would of course never be used by the prosecution. In fact, statements merely intended to be exculpatory by the defendant are often used to impeach his testimony at trial or to demonstrate untruths in the statement given under interrogation, and thus to prove guilt by implication. These statements are incriminating in any meaningful sense of the word, and may not be used without the full warnings and effective waiver required for any other ID. Quoting Miranda v. Arizona, 384 U.S. 436, 476-77, 1966. The standard for assessing a suspect's custodial status is whether a reasonable person innocent of any wrongdoing would have believed that he or she was not free to leave. Pullman, 5 NY, 3D at 129, People v. Yarkle, 25 NY, 2D 585, 589, 1969. The test is not what the defendant thought, but rather what a reasonable man, innocent of any crime, would have thought had he been in the defendant's position. The burden is on the people to prove beyond a reasonable doubt that the individual was not in custody before Miranda warnings were given. People v. McCoy, 89 AD 3D 1218, 1219, 3rd Dep 2011. People v. Baggett, 57 AD 3D 1093, 1094, 2008. The people bore the initial burden of proving beyond a reasonable doubt that defendant's statements were voluntary. Here, this required proof that defendant was not subjected to custodial interrogation before Miranda warnings were administered. Citations omitted. 2. Mr. Mangione's statements to law enforcement in the McDonald's should be suppressed when Patrolman Detwiller and Fry, fully armed and in uniform, first approached Mr. Mangione at the McDonald's. He was seated at a back table with a wall behind him, a wall to the left of him and a table in front of him. X6A, 1 at 9 hours, 29 minutes, and 12 seconds. Instead of approaching Mr. Mangione from the front of the table, Patrolman Detwiller strategically positioned himself to Mr. Mangone's right, thereby preventing Mr. Mangione from leaving the table and exiting the McDonald's. AA Motorola Solucio, X6B, 1 at 9 hours, 29 minutes, and 15 seconds. Patrolman Detwiller asked Mr. Mangione to pull his mask down and immediately knew that Mr. Mangione was the New York City shooter. HR 19798. That Patrolman Detwiller asked Mr. Mangione to pull down his mask before even asking his name would have indicated to any objectively reasonable person innocent of a crime that Detwiller was trying to make an identification. Similarly, that Patrolman Detwiller positioned himself to block Mr. Mangone's only exit route from the table where he was sitting would also raise concerns to that objectively reasonable person that Detwiller was attempting to prevent him from leaving the area. The concern that Mr. Mangione was a suspect further increased when Patrolman Detwiller told him that someone called and said he was suspicious, followed by Detwiller asking to frisk Mr. Mangione even though Mr. Mangione had not done anything wrong in the 75 seconds since he was first approached by Detwiller. Patrolman Detwiller then asked Mr. Mangione why he was nervous, as Detwiller frisked Mangione for more than 15 seconds. Patrolman Detwiller then indicated to Patrolman Fry that Fry should assume the strategic position blocking Mr. Mangione where Detwiller had been standing, so that Fry could continue to talk to Mr. Mangione. In addition, Patrolman Detwiller had purposely not given Mr. Mangione his identification card back and had pinned it to this shirt pocket indicating that he would not be giving it back anytime soon. When all these circumstances are put together for an objectively reasonable person innocent of a crime, the following picture is painted. Law enforcement believes the individual is suspicious, is trying to make an identification, is frisking the individual even though he had been doing nothing wrong, while, at the same time, law enforcement is asking him why he is nervous, is making it clear that they had no intention of returning his identification, and is blocking the only exit that the individual has to leave his interaction with law enforcement. To this reasonable individual, law enforcement's decision to block his exit seems intentional because Patrolman Detwiller made certain to position Patrolman Fry closer to Mr. Mangione to prevent his exit when Detwiller walked out of the McDonald's. The totality of these circumstances would indicate to the objectively reasonable individual that he was not free to leave. Furthermore, at the hearing, Patrolman Detwiller testified that, once he recognized Mr. Mangione as the New York City shooter, which was immediately after Mr. Mangione pulled down his mask at 9:29 a.m., Mr. Mangione was not free to leave the McDonald's until Patrolman Detwiller identified who he was. HR 307. This testimony also supports the argument that Mr. Mangione was in custody for Miranda purposes soon after Patrolman Detwiller and Fry approached Mr. Mangione at the back of the McDonald's. See People vs. Parks, 120 AD, 2D 920, 921, 4 Dep 1986, relying on the fact that the arresting officer admitted that defendant was not free to archive in determining that, under the circumstances, a reasonable man, innocent of any crime, who was being restrained and questioned by 1 or 2 police officers, would believe he was in custody. Accordingly, given the totality of the circumstances listed above and Patrolman Detwiller's testimony that Mr. Mangione was not free to leave, any interrogation from this point forward, 9 hours, 30 minutes, and 59 seconds AM, would have been custodial interrogation, and therefore all the statements Mr. Mangione made from this point until he received Miranda warnings should be suppressed. 3. This would include the following statements that Mr. Mangione made to Patrolman Detwiller and Fry based on their custodial interrogation. Up to this point, the only statements Mr. Mangione had made to law enforcement were that his name was Mark and Mark Rosario, that he was from New Jersey, and whether he had been up to New York recently. Counsel does not move to suppress these statements. There can be no doubt that these questions were intended to elicit an incriminating response, as Patrolman Detwiller and Fry were trying to establish that Mr. Mangione was in New York recently, that he was not from New Jersey as his identification indicated, and that he had no reason to be M.A. Tuna and Ozzy Varnia. Statement time, in response to Fry asking what's going on and what brings Mangione up from New Jersey. I am just gonna wait to see what you guys are up to. I'm just gonna wait 9 hours, 31 minutes, and 34 seconds, 9 hours, 31 minutes, and 37 seconds, in response to Fry asking whether Mangione wants to talk to him and stating they had been called about a suspicious person. I mean, what's going on? I'm just trying to use the Wi-Fi, I can't use the Wi-Fi. 9 hours, 31 minutes, and 40 seconds, 9 hours, 31 minutes, and 48 seconds, in response to Detwiller asking if Mangione is from New Jersey. MHM 9 hours, 32 minutes, and 17 seconds, in response to Detwiller asking whether Mangione is visiting family in Altoona. UH, no, I'm homeless, sir. 9 hours, 32 minutes, and 57 seconds, in response to Detwiller asking if Mangione's been up in New York recently. UH, no sir. 9 hours, 33 minutes, and 12 seconds, in response to Detwiller asking how long Mangione's been at the McDonald's. About 40 minutes. 9:33, 40. I was just trying to get out of the rain, to be honest. 9 hours, 34 minutes, and 0 seconds, in response to Detwiller asking what brought Mangione to Altoona from New Jersey. I mean, I haven't been to New Jersey for a little bit, moving around. 9:35, 5, in response to Detwiller asking Mangione if he's from New Jersey. MV, yeah, DMV like, yes, and the surrounding states. Moved around a bit when I was younger. Sorry. 9 hours, 35 minutes, and 21 seconds. 9 hours, 35 minutes, and 31 seconds. Delaware, Virginia, yeah, exactly the same. 19 hours, 35 minutes, and 36 seconds. 9 hours, 35 minutes, and 38 seconds, in response to Detwiller claiming that they've been to the McDonald's multiple times for people staying too long. I mean, this is like my receipts from 8:55, 9 hours, 36 minutes, and 10 seconds. I wish they would have just told me. I would have just gotten up and left. 9 hours, 36 minutes, and 18 seconds, in response to Detwiller asking Mangione what he was eating. MHM, it's good. It's my first time having it. It's good. 9 hours, 38 minutes, and 9 seconds. 9 hours, 38 minutes, and 13 seconds. UH, what should I do next time to not get 9 hours, 38 minutes, and 55 seconds? To the extent the district attorney's office argues that Mr. Mangione was not in custody at this point. 9 hours, 30 minutes, and 59 seconds AM. Mr. Mangione was certainly in custody once additional officers responded to the back of the McDonald's and limited Mr. Mangione's movements even more. By 9 hours, 42 minutes, and 36 seconds AM, there were 8 officers in the McDonald's near Mr. Mangione. Patrolman Detwiller, should the district attorney's office argue that this statement was initiated by Mr. Mangione, the New York Court of Appeals has noted that the fact that the defendant may have initiated the exchange is not necessarily controlling because statements made in response to police questioning or during a long informal discussion are not truly spontaneous, even though defendant may have made the opening remarks. People v. Rivers, 56 NY, 2D 476, 479, 1982. Patrolman Fry, Lieutenant Hanelli, Sergeant Burns, Corporal Trent, Corporal Miller, Patrolman McCoy and Patrolman Yeager. Additionally, 3 of the officers, Patrolmen Fry, Detwiller and McCoy, had surrounded Mr. Mangione at the back of the McDonald's, preventing him from leaving the table area. Emotional A Sol, X6A, 2 at 9 hours, 45 minutes, and 32 seconds. Mr. Mangione had been told by Patrolman Detwiller earlier that officers were called to the McDonald's because he had been there too long. Considering the incongruity between the number of officers responding, 8, to the nature of the police call, loitering, as well as the officer's strategic positioning limiting Mr. Mangione's ability to move, any objectively reasonable individual in this situation would believe that he was not free to leave. Accordingly, because Mr. Mangione was in custody when 8 officers were preventing him from leaving the McDonald's, 9 minutes and 42.30 seconds AM, any following statements through Miranda warnings must be suppressed. Statement time, in response to McCoy asking Mangione about his property. Yes, 9 hours, 42 minutes, and 58 seconds, in response to McCoy asking whether Mangione knows what all this nonsense is about. I'm going to find out. I guess. 9 hours, 43 minutes, and 41 seconds, in response to McCoy asking Mangione if he walked to the McDonald's. It's been raining. Yeah, 9 hours, 43 minutes, and 47 seconds, in response to McCoy asking Mangione whether he has a vehicle. I'm just gonna let all this play out. 9 hours, 43 minutes, and 55 seconds, calling a couple more cars. 9:44. 4 This is a puffy jacket, I'm not very big. 9 hours, 44 minutes, and 7 seconds, in response to Detwiller asking whether Mark Rosario is Mangone's real name. No sir. 9 hours, 47 minutes, and 13 seconds, in response to Detwiller asking Mangione what his name is. Luigi Mangione, spells out name. 9 hours, 47 minutes, and 18 seconds, in response to Detwiller and Fry asking Mangione for his date of birth, May 6, 98, 9 hours, 47 minutes, and 39 seconds, in response to Fox asking Mangione why he lied about his name. Clearly I shouldn't have. 9 hours, 48 minutes, and 3 seconds, in response to McCoy asking Mr. Mangone's middle initial, N for Nicholas. 9 hours, 48 minutes, and 11 seconds. 9 hours, 48 minutes, and 13 seconds, in response to Fry asking Mangione why he lied. That was the ID I had in my wallet. I had a fake ID, and I handed that one. In response to Fox asking Mangione if he had a fake ID. Yes. 9 hours, 48 minutes, and 18 seconds. 9 hours, 48 minutes, and 25 seconds. At 9 hours, 48 minutes, and 31 seconds, Patrolman Fox hurriedly read Mr. Mangione his Miranda rights. At 9 hours, 48 minutes, and 47 seconds, Patrolman Fox asked Mr. Mangione if he understood his Miranda rights, to which Mr. Mangione responded, "Yes, sir." Patrolman Fox then asked Mr. Mangione if he wanted to speak with law enforcement. Mr. Mangione first nodded his head indicating no, and then stated, "No, I don't think so." X6B, 1 at 9 hours, 48 minutes, and 55 seconds. As the Supreme Court has ruled, a defendant's invocation of his right to remain silent must be scrupulously honored. Michigan v. Mosley, 423 U.S. 96, 104, 1975. The same is true under New York and Pennsylvania law. See, for example, People v. Ferro, 63 NY, 2D 316, 322, 1984. IA, a suspect's right to remain silent, once invoked, must be scrupulously honored. Int of GEW, 233A, 3D 893, 899. PA, Super 2020, once a person asserts his or her election to remain silent, the right must be scrupulously honored by the authorities. Yet, in violation of Supreme Court, New York and Pennsylvania law, after telling Mr. Mangione that he was under an official police investigation and despite Mr. Mangone's clear invocation of his right to remain silent, Patrolman Fox asked Mr. Mangione why he had a fake ID, at 9 hours, 49 minutes, and 32 seconds. Mr. Mangione again invoked his right to remain silent. This is yet another example of Altoona law enforcement violating Mr. Mangone's constitutional rights as they attempted to collect evidence for the NYPD to use against him. Because Mr. Mangione asserted his right to remain silent, all questioning that followed should be suppressed, including the following: 85-86 statement time, in response to false ID warnings. No, I don't think. I'm sorry, can you say the last part again? 9 hours, 48 minutes, and 54 seconds. 9 hours, 49 minutes, and 19 seconds, in response to Fox repeating false ID warnings. Got it. 9 hours, 49 minutes, and 29 seconds, in response to why he had a fake ID. I'm gonna remain silent. 9 hours, 49 minutes, and 37 seconds. 9 hours, 49 minutes, and 39 seconds, in response to Fox asking Mangione to stand up so he could pat him down. Sure thing. 9:49, 58. This is the jar of peanut butter, by the way, you can take that, just letting you know. 9 hours, 49 minutes, and 59 seconds. 9 hours, 50 minutes, and 2 seconds, in response to Fox asking if Mangione had any weapons on him. No. 9 hours, 50 minutes, and 7 seconds, in response to Fox asking about the jar of peanut butter. You can take it layer of peanut butter out if you want. 9:50. I have a pocket knife. Does that count? 9 hours, 50 minutes, and 14 seconds, in response to Fox asking where the pocket knife is right pocket, 9 hours, 50 minutes, and 16 seconds, in response to Fox asking to grab the pocket knife, sure thing 9 hours, 50 minutes, and 18 seconds, in response to Fox asking to grab the pocket knife, right here, yup, 09, 5112, in response to Fox asking if Mangione had any other knives, number 9 hours, 51 minutes, and 26 seconds, in response to Fox stating Mangione provided a fake name. No, it's not. That's my name. 9 hours, 52 minutes, and 3 seconds. 9 hours, 52 minutes, and 6 seconds, in response to McCoy asking what state Mangione would have an ID from Maryland. 9 hours, 52 minutes, and 11 seconds, in response to Fox asking Mangione about his date of birth, the 5th of June 1998 is correct. That's real. In response to Burns asking Mangione his age, 26, 093226-095218. Can I ask why there are so many cops here? 9 hours, 56 minutes, and 28 seconds, in response to question about whether something in bag they need to know about. Just gonna remain silent. 109 hours, 58 minutes, and 15 seconds. Mangone's statements to corrections officers Henry and Rivers should be suppressed at the suppression hearing. Correction officers Henry and Rivers testified to statements that Mr. Mangione allegedly made to them on December 10th, 16th and 17th, 2024, while he was in custody at SCI Huntingdon, a state prison in Pennsylvania. Notably, none of these statements were ever written down by the officers and were first memorialized when the officers were interviewed by the district attorney's offices weeks later. As to C.O. Rivers, he testified that he and Mr. Mangione had conversations discussing, inter alia, health care and Ted Kaczynski on December 16th and 17th, 2024, H.R. 8791. At the time of these alleged statements, C.O. Rivers knew that Mr. Mangione was represented by counsel. C.H.R. 98, C.O. Rivers noting that he believed that Mr. Mangione was given the opportunity to make phone calls to his attorney. Under New York's indelible right to counsel rule, a defendant in custody in connection with a criminal matter for which he is represented by counsel may not be interrogated in the absence of his attorney with respect to that matter or an unrelated matter unless NE waives the right to counsel in the presence of NE's attorney. People v. Lopez, 16 NY, 3D 375, 377, 2011. This rule applies even though it was a Pennsylvania officer who was having conversations with Mr. Mangione that related to the New York case. See People v. Young, 181 AD, 3D 1266, 1267, 4th Dep. 2020. Here, defendant's indelible right to counsel attached at the time of the preliminary arraignment by virtue of his request for counsel during that proceeding, and it was therefore improper for the Pennsylvania state troopers to subsequently interview him about the New York offenses, notwithstanding the fact that the public defender had not yet been assigned. In reaching that conclusion, we note that even though the interview was carried out by Pennsylvania state troopers, their interrogation is nevertheless subject to this state's right to counsel jurisprudence inasmuch as they were agents of the New York police officers. It would have been clear to C.O. Rivers at the time of these conversations that the topics of health care and Ted Kaczynski related to the New York shooting, which had been widely reported on in the news based on law enforcement leaks. By having these conversations and eliciting information that the New York prosecutors would seek to use at trial, C.O. Rivers' conversation was an interrogation. See Rhode Island v. Innes, 446 U.S. 291, 302 N. 5, 1980, the Supreme Court defining the phrase incriminating response in the Miranda context to refer to any response, whether inculpatory or exculpatory, that the prosecution may seek to introduce at trial. Because C.O. Rivers knew that Mr. Mangione was represented by counsel at the time of these conversations, he violated Mr. Mangone's indelible right to counsel by engaging in these conversations, and the statements about healthcare and Ted Kaczynski must be suppressed. As to the statements allegedly made to C.O. Henry, he claims that Mr. Mangione, without any prompting or questioning, spontaneously blurted out statements on December 10, 2024, that Mangione had a backpack with foreign currency and a 3D printed gun inside. HR 137, 147, 162-63. CO Henry further incredibly testified that he did not initiate or respond to Mr. Mangone's statements. HR 138, 147, 149, 150, 157, 163. CO Henry further claims that Mr. Mangione made these statements even though it was the first day he was assigned to watch Mr. Mangione and they had never met or spoken before. HR 164, in essence, CO Henry is expecting this court to believe that Mr. Mangione, without any prompt or questioning, just started making incriminating comments to CO Henry, a complete stranger, and that Henry did not respond at all or write anything down at the time. Such testimony strains common sense and credibility, is unworthy of belief, and cannot be the basis for the District Attorney's Office to meet their burden regarding admissibility of Mr. Mangone's alleged statements to CO Henry. See, for example, People v. Barrios, 28. Y. 2D 361, 369, 1971, where the judge at the suppression hearing determines that the testimony of the police officer is unworthy of belief. He should conclude that the people have not met their burden of coming forward with sufficient evidence and grant the motion to suppress. See generally People v. Owen, 42 NY, 2D 1064, 1066, 1977, given a finding that the officer's testimony was not worthy of belief. A review of the record reveals no other evidence whatsoever which would be sufficient to provide reasonable cause for the subsequent search of the defendant's person and his automobile. Under these circumstances, the motion to suppress should have been granted. People v. Carmona, 233 AD, 2D 142, 144 as Step 1996, it is well established that the people, faced with a constitutional challenge to a search and seizure, bear the burden of going forward with evidence to show the legality of the search in the first instance. The testimony offered by the people to meet this burden must be credible, and cannot be credited when it appears tailored to nullify constitutional objections, or where such testimony is physically impossible, manifestly untrue, contrary to experience, or self-contradictory. Citations omitted. People v. Quinones, 61 AD 2D 765, 766 is Step 1978, rejecting the officer's testimony as a matter of law where the testimony has all appearances of having been patently tailored to nullify constitutional objections. Accordingly, this court should suppress the statements that Mr. Mangione allegedly made to CO Henry. Conclusion: for the reasons stated in counsel's April 30th, 2025, omnibus motion, at the December 2025 suppression hearings and in this post-hearing submission, we respectfully request that this court grant the requested relief. 88 respectfully submitted, KRR Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, counsel for Luigi Mangione.
That is the end of Karen Agnifilo's pre-hearing memorandum of law that came out on the 30th of January 2026 in Luigi Mangione's case. And again, like I said earlier in the video, I'll go over my little notes and breakdown of this document on my next video on Luigi Mangione's case, going over the updates and all that. It's just a lot more easier to record and take notes down while I'm doing this when I'm recording the audio for this document than doing it separately like I used to do that. I think it's more convenient and time-wise, I think, anyway. Hopefully that'll be next week's video. We'll see. Again, there's a lot for me to cover. I need to break down and all that. But that is the end of this document, and hope you guys liked this video. Hope you guys enjoyed it. Thank you for watching this week's video. You can subscribe if you want to. It's okay if not. I upload 3 times a month, and if you guys want to keep up to date with the channel, you can follow the channel's social medias. That's where I post little updates what's going on with the channel, just things I find interesting, and sometimes little news articles and all that. Or you can just like send me little articles. I will read them eventually. I do find them very interesting. Thank you guys for sending me articles about stuff. I do appreciate it a lot. And if you guys want to follow me personally, all my social media is down below. And fun little fact, I don't ever know how to end these videos after I do that stupid little script I have to do every time. I don't ever know how to end these properly. It's always a little bit awkward. Thank you for watching this video. Bye!